Meeting of the Texas Department of Licensing Regulation will now come to order. Um, Let's go on to the roll call, if you don't mind.
Mike Arizmendez,
Present.
Tom Butler,
Present.
Helen Collier is absent today. Rick Figueroa,
Present.
Catherine Rodwald is absent today. Ravi Shah,
I'm here.
Deborah Yurko.
Present.
We do have a quorum for this meeting. I want to go back and we have been fortunate to have some great members and great commissioners on this, I would say esteemed body, but I'm on here, on this body of commissioners. So we want to welcome our new commissioners, Rick Figueroa. We've heard some great things. I know that you're going to bring a lot to the table, so we're looking forward to it.
Thank you.
And Helen Collier, who is not present, actually had a previous appointment or previous engagement prior to being appointed, so we knew that she wouldn't be here on this day. So we want to welcome her also. I've actually had the fortune of meeting both these commissioners during the training, and I think that we're going to be in for some very high-level type thinking, which is really going to put a cramp in our style. So. So we look forward to having you guys on here, though.
Thanks, Mike.
But more than anything else, we want to say goodbye to a couple of commissioners that have been with us for 12 years. They're actually in the audience, and we're fortunate to have them back. Former Commissioner Lou Ann Morgan and former Commissioner Fred Moses. I just want you to know, and on my behalf, it's been a pleasure to serve with you. I've absolutely thoroughly enjoyed it. You have brought a great jail to this to this commission. We may not have been always on the same side, but I tell you what, we walked out of here we always ate at the same table, which to me is the epitome of what a commissioner should be when you begin to start talking about this. So, commissioners, do you have anything else you'd like to bring?
I would. I'm going to miss both of you terribly, but congratulations on your parole.
Mr. Butler, Mr. Shaw.
I would. I'd just like to say, Fred, I'm going to miss you terribly. Just your camaraderie. We've gotten to be such good friends, and it's going to leave a hole in my heart. And Lou Ann, you brought so much. I appreciate you, the person that you are, and what you brought to this commission. The way you approach things was unique, and we're going to miss that, and we're going to feel it. Also looking forward to Rick. I feel like I've gotten to know you a little bit, and this is going to be a great experience, I think, for both of us. More for me than you, but.
Well, thank you very much for serving on the commission, both of you. I think you've been great mentors. I've kind of learned a lot from both of you over the last 2.5 years. Learned what was right, what was wrong, and how to deliberate, how to discuss, and most importantly, how to think things through. I know this is going to be a tough decision for all of us as you move on and move forward, but as we bring in new commissioners, maybe we can learn from your mentorship and maybe learn to mentor them. So thank you again.
I didn't know if you guys wanted to come up and say anything at this point. I'll open it up for you to be able to say something. So, yeah, I need you to come to the front and please state your name.
Time's so long.
Stick to just the facts.
Yeah. Remember, just the facts of the case, please.
That's the facts.
Lou Ann Morgan. I think this has probably been one of the greatest experiences I've had, and so Rick, you're in for a great ride. You'll learn quite a bit, and you're working with a great team, not only commissioners, but one of the best things about this commission is the employees. It takes the people that you work with, the employees, to make this such a great commission to work for, and it's just amazing that, and I was saying earlier that Fred and I were talking on the way up here, about another commission, and this is one of the best commissions to be on. I've got to commend the group of people that work here. They're just amazing, and they make your job so easy. So you're in for a great ride. The team, the commissioners, you agree to disagree. That's the best part about it. There's no hard feelings. That's what I like the most, is that you had your discussions, you had your meetings, and then you walked out, and it was over. And that it was just very productive, and that was probably the most beneficial part of everything about it was you know, at the end of the day, it was a good meeting. And so I can't say how much I learned from being on this, and it was the best 12 years I've had. So thank you all for the opportunity.
Fred Moses, and I feel like I kind of grew up in this commission in the last number of years, but can't say enough for working with the commissioners and Bill and Brian and all the other staff, and how we've worked together and served the people of the state of Texas. And it's been such an honor to over the years to get to know each other and to love each other and to serve and to do this work. And it is a work. It's important work, and to see how this agency has grown to be a premier agency in the work that that everybody has done. So thank you for all the thanks the Lord for putting all of you in my life. I've I don't know, maybe I've grown a half inch since I but that's good. And but it's all good. And so but most of all, importantly, the great work that we've been able to do, and it's shown that, and you still have a and then now you go into a new level with new leadership and new inputs, and so what a great work that is. Thank you very much. Thank you. Thanks everybody for the opportunity to serve.
We've got actually one for each of you. We received a proclamation from the governor, and this is what it states: State of Texas Governor, to all to whom these presents shall come, greetings. Know ye that this official recognition is presented to Lou Ann Morgan in recognition of and appreciation for her years of meritorious service to the state of Texas as a member of the Texas Department of Licensing and Regulation Commission, as from 2004 to 2016, and it is affixed with Governor Greg Abbott's signature on there. We have one for Fred also. So we want to be able, on behalf of the commission and the state of Texas, thank both of you for your work that you did, and we hope that you take that back with you. And we'll stop there. We've got additional parting gifts for you. So let me get something that the executive staff worked on extensively.
No cake. It was all cake. This is Fred's.
There's a scrapbook that's been created that, Fred, for you, that was done, and I haven't had a chance to look at the scrapbook, so during the break, I probably want to take a look at it to see kind of where you're at, and see if I'm in any of those pictures. So, sure.
Bill?
But there's more. Yeah, we're not quite done yet. We should get Robbie, Deborah.
Well, you should get it two times.
I was told it was gonna be hot in here today. I didn't bring a jacket, I didn't bring a tie.
You fell for it.
I fell for it.
Brian did.
Oh, yeah, you can fit in.
That's so neat.
Okay. We do have, again, there's still a couple others that we want to get. I think Bill and Brian are now gonna step in and take over. Yeah. Go put these over here. I hope you can carry these back.
Yeah, we're
It's kind of interesting how that's a term, an introduction, I think will always call you Commissioner Moses, Commissioner Moses. So from the staff, we have a letter from Bill and from the chairman, and what it does, it tries to document as best as possible the contributions and the leadership that you made to the agency. Under your watch, and you guys have been here for a while, you've been here longer than my daughter's been alive. And it feels like she's been alive for 100 years. But the contributions and the things that we've seen and we've been able to do collectively as an agency, the wisdom, the philosophy, the faith that you both have, it's reflected in TDLR every day. The way that we treat people and how you treated folks that sat at the table, whether you agree with their position or not, you always show them the utmost amount of respect. And that says a lot, but that is reflected in our staff. Our staff sees how you treat those that come to us, and that goes to our everyday. It's part of our core values. You were living them before we wrote them. You were living in respect, you were living in integrity before we wrote those and defined them. And so we're grateful for the opportunity to do that. The fee cuts that we've been able to do over the years, that's a big deal. Is it on? Okay. So the fee cuts to our licensees, there's agencies out there that have gone years that have never lowered one fee. And to say that we've lowered $32.5 million collectively for our licensees together, that's a major statement. We walk the walk here at TDLR, and you guys helped us set that standard. So from all the staff, we want to tell you thank you, and I'm going to put the mic down.
Well, because my retirement is imminent, I've been thinking about different things like this, and the accomplishments, the big accomplishments are something that's it's in the resume and all, but the important things are the little things. And it's the support that we've had for each other and the support that you have given us that has allowed us to have the culture that we have, that then allowed us to achieve the things that TDLR's achieved. And it's those little things that make the big, big difference. And I really appreciate the guidance that you gave us and all the support that you gave us and all the little things that you did for the agency.
Well, I was going to say, one of my favorite moments was going to visit Fred at his company and seeing where he works, where he lives, and the respect that his employees have for him in such a family environment. And sitting there with him over those hours, I learned a lot about leadership and being a man. And then Luann had me on a program where I had to speak to a room full of people who were eating rubber chicken at the time that I was speaking. And it was fantastic to see how respected you are in your communities and how much you guys give back to your groups. And that carries over. So I think we're going to take a picture, and then we have some gifts still. Yes. Yeah, we do it out. Okay. Rick, you're going to get this too. Yep. All right. Great. And there's more.
All these gifts, they're really happy to get rid of y'all.
We'll take this from you.
This is what you're looking for? Yes. Okay. I had Tamala resend them in your email too.
So,
Here's Dropbox.
this is from the executive staff.
Here's a 622, which is today. You have 3 different ones here that you can open.
Yes,
They're like neon pictures of each of us.
I also had them send, I checked your mail's open. I had Anthony send a test, he's my coworker.
Designated paper holder.
He didn't get an email. It goes to
This is just,
Dropbox.
that's just this right here.
Right. So you have 3 different documents here, and those are sent to Dropbox.
You got this. You got this. You can do this. Little bling bling.
Okay. Very nice. Very nice. Thank you very much. Thank y'all. How about that? Wow, very nice. Thank y'all very much.
Absolutely.
I hate computers are smarter than me.
I appreciate your service again. We're going to take a short little break to allow the employees to come in and bid farewell to our great teacher.
See, because maybe
Take a short break for about 8
Oh, thanks.
this is my phone.
Yes.
thinking maybe, one of the TOR numbers.
Yeah, you could do that. Sure. And then you just handwrite on it, your private number if you want something. I remember.
Second.
We have a motion and a second. All in favor, signify by saying aye.
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 Those opposed, motion carries. Let me get back to my agenda here. I know that we do have individuals present that would like to make some comments. Normally, the public comments at the end. I'll go ahead and move it to the front because I believe that I don't intend for you to go ahead and stay here for this whole meeting that way. If there's someone here that'd like to make a comment, a public comment, feel free to come forward. I believe that I've got.
I would.
Okay. Did you fill out a?
Yes, I did.
Okay. Here it is. Matt
Garbaz.
Garbaz. Come on up, Mr. Garbaz. At this point in time, the public comment form is simply an opportunity for you to be able to present information or to visit with the commissioners. According to state law, we are not be available to respond back to you, but simply listen. So just kind of for your information. So after you're done passing this out, if you don't mind, you can just have a seat, state your name for the record, and you'll have 3 minutes in which to speak.
Yes, sir.
Our General Counsel, Brad Bowman, will be keeping track of the 3 minutes.
Might give me a little bit extra. I drove 8 hours to get here. My name is Matt Garbaz, and I'm here to represent family and friends, community. My wife Suzanne, my daughter Alana, who couldn't make it because of work requirements, and my little granddaughter Lillian, who's 3. First, I want to thank everybody for letting me speak here today, having the opportunity. I also understand that sometimes the governor has a rep here, and I'd like to speak with them if they're available at the end of the meeting. Giving you a little pamphlet that's kind of an overview of what I'm going to be talking about. It's a brief history of our story. This is the story of a terrible tragedy. It didn't have to happen. May 11th, 2013 started out as one of the greatest days in our lives. Our beautiful Lillian was born. It quickly turned into the worst day of our lives. My daughter Amanda died under the care of a midwife and a so-called doctor. Due to their inaction, negligence, and arrogance, my daughter bled to death. With the move of the midwifery board from DSHS to TDLR, I think we can improve the safety of the midwife's profession. I come here before you today with a list of changes to the midwife laws and rules that address the need for improved transparency and safety in the midwife profession. With your help and your oversight of the midwives, we can make needed changes to the rules and regulations. These changes will help protect the most vulnerable in our society, mothers and infants. Your pamphlet right there on, I think on the second, maybe the third page, has kind of a list of bullet points there that we're kind of wanting to change. The first one, there needs to be a question on the application for license asking if the applicant has ever been sanctioned. If it is found they lied on the application, the license gets revoked immediately. Ms. Cooper, the midwife, was sanctioned in Arkansas. The previous midwife board was unaware of this fact. She just jumped states. Number two, there needs to be a required disclosure that a midwife is not required to carry malpractice insurance in the state of Texas. Neither the doctor nor the midwife had in our case. It's not required by law. We have, Amanda was a civil engineer, going to have a substantial income over her life. We have no recourse now to try to recoup any of that for my granddaughter. That and the tort reform laws, which put a cap on the any malpractice at 1.8 million. You can slip on milk at Walmart and get more money. I'm a contractor. I'm required to carry $1 million worth of liability insurance, and all I do is build stuff. There needs to be a mandatory, not voluntary, national registry, which there's voluntary now, following midwives by social security number, not just license number. As I said, the midwife was reprimanded in Arkansas. She chose not to accept the sanction, and she moved to Texas. She had, I think, 4 businesses under AKAs, different names. Same thing contractors do. She just changes her name, moves. There should be a mandatory suspension when there is a death of a mother or a child until a tragedy can be investigated and resolved. We filed a complaint in December of 2013. It took over a year for the inspectors to investigate it. In February of 2015, we got a sanction. She appealed, had a administrative hearing in October of 2015. We just got the sanction in June of 16, 3 years. She's been doing business in this time period for 3 years. So we'd like to have a mandatory suspension whenever there's a death. Pretty simple. When there's a request to call 911 or transfer to the hospital, the request is granted immediately. No trying to talk the patient out of it, no second guessing. The home birth is immediately over. My daughter asked multiple times to go, and she was talked out of it. A doctor's a midwife's kind of a authoritative figure. She was under stress. They talked her out of it, and that was fatal to her. Fatal. She bled to death. Transfer rates is a big deal with midwives. They don't like transfer rates, but they want to keep it as low as possible. Makes them look good. There needs to be a form that explains the risk of not being in a hospital setting and a list of conditions that make you a high-risk patient. Amanda had several conditions that classified her as high risk. She didn't know this. There needs to be a connection between the midwife and the hospital. The patient will be transferred to in the case of an emergency. Before the birth, the hospital should have all necessary medical history on file and a detailed map and address of birthing location. When the birth starts, the hospital is notified. For this fact is the hospital didn't have any records of her. They didn't get transferred from the midwife to the hospital. The EMTs got lost. So we needed that time, those seconds counted. These little changes here. This is not an indictment of all midwives. The majority of midwives are well-educated and conscientious. We hope the midwives of Texas will help us implement these changes. It is to their advantage to disassociate themselves from substandard midwives. In closing, I'd like to say no one should have to go through the pain and suffering we've had to endure. This pain will be with us our whole lives. I have a granddaughter that shares her birthday with the death of her mother. I have a daughter that lost her best friend. I had a wife whose daughter died in her arms. This tragedy has affected so many people's lives. I'd like to thank you again for the opportunity to tell our story. I thank you in advance for your help and the right decisions you'll make in the future. Thank you.
Mr. Gomez, thank you for your time, and my condolences on your loss. At this point in time, is there anyone else that'd like to come before the commission to speak? If not, we'll go ahead and enter into item D, which is executive session, consultation with staff attorney pursuant to 551-071 of the Government Code, to receive a briefing from general counsel concerning pending or contemplated litigation or settlement offers, including but not limited to the Patel versus TDLR. Advice from general counsel on legal matters authorized by 551-0712. And then under section 551-074 of the Government Code, discussion of personnel matters. So at this point in time, we'll go into executive session.
December?
It is now 10:06, and coming out of executive session, there's no action on anything coming out of executive session. So let's move on to item number F, which is approval of the minutes. Commissioners, you've had a chance to review the minutes. I'll entertain a motion or corrections if needed. Okay, how about just a motion? So moved. A motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's go to item G1, contested cases. Johnny Ray Norman. If you're here for a contested case, if I happen to miss you, I don't have anybody signed up for it, but if I happen to miss you, just raise your hand, jump up and down, touch the ceiling, do something, let me know that you're out there. But is anyone here for Johnny Ray Norman or Mr. Norman?
Good
Charlotte, go
morning,
ahead.
Chairman Ares-Mendez, Commissioners. My name is Charlotte Melder, and I'm one of the senior prosecutors here in enforcement. Mr. Norman, the respondent in this case, is an auctioneer. Auctioneers are required to pay the seller of the goods that they auctioned within 15 days of the auction or whatever time frame specified in the contract. In this case, the contract between the parties allowed for 20 days for payment to be made. Mr. Norman owed the seller in this case about $2,500. The auction in question was held in June, so the payment was due in July. The seller, however, did not receive payment until December, 5 months late. At the hearing, Mr. Norman admitted that he was angry because the auction had been a nightmare for him because of the seller, and that he had ultimately taken a loss from the auction. Despite his feelings, he claimed that he had had the required payment mailed to the seller on time, but that it had come back to him for postage due. He did not bring the envelope or submit any proof of that actually happening. His reason for not immediately mailing the payment again, this time with proper postage, was because he claimed that he had called the seller and offered to hand deliver the payment, but the seller had refused. The seller, by the way, denied that conversation ever took place. The respondent acknowledged that payment was not ultimately made until December, after the department got involved. The department only sought a penalty of $3,000 for this Class C violation, even though this was Mr. Norman's second violation of not timely paying someone. The judge found that the department met its burden and recommended the minimum for a Class C violation of $2,500 and asked that the commission consider reducing this further because the ALJ believed the seller had essentially frustrated Mr. Norman. I'm asking that you adopt the PFD as written, and I'm happy to answer any questions that you may have.
Any questions for Charlotte or Ms. Melder? I'm sorry. Motion to be in order?
If there's no discussions, Mr. Chairman, I'd like to make a motion to adopt the PFD as presented.
We have a motion and second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 2, 6 on
Sancheng.
Sunchain? Okay.
All right, again, Charlotte Melder with enforcement. Mr. Sancheng, the respondent in this case, is a coach of Muay Thai fighters and holds a license as a second with the department. The ALJ found that the department met its burden on the main violation alleged, that the respondent did not behave in a professional manner at all times pertinent to an event and exhibit the highest degree of sportsmanlike conduct. That's what the law says you have to do when you hold the license. The ALJ proposed a penalty of $5,000 and a 1-year probated suspension of his license for this violation due to the severity of the outcome of what happened after his actions. This case centers around a bout between 2 fighters that was stopped by the referee because one of the fighters, the one coached by Mr. Sancheng, had stopped defending himself. Mr. Sancheng immediately jumped into the ring and started arguing with the referee. What transpired next included the referee being punched, many other people jumping into the ring, and general havoc reigning. All of this was recorded and admitted into evidence. The recording shows Mr. Sanchang jumping into the ring and the resulting riot-like situation, all the way to his being escorted out of the arena by security, fighting with that security, trying to get at spectators, etc. The respondent testified about a myriad of things, all attempting to downplay or find a loophole to justify his actions and his role in the fight that broke out. However, the ALJ, quoting the actual PFD, the evidence is clear that the respondent entered the ring before a decision had been announced, refused to leave when told to do so by the referee, and only left the ring after struggling with others in the ring. None of these acts can be considered to be behaving in a professional manner and exhibiting the highest degree of sportsmanlike conduct as required. The attorney has presented a document with his arguments. He's not here today. In response to the comments that he made in that document, I would argue that, again, these are attempted loopholes. His behavior is extremely unsportsmanlike and unprofessional, and trying to say he wasn't there in that capacity when he was does not discount his behavior. I am asking that the commission adopt the PFD as written, and I would be happy to answer any questions.
And I have asked, there's no one here representing Mr. St. John or St. John himself.
Wasn't there a letter?
There's a letter, you should have a letter that's marked G2 of the information that we received. It is from his attorney, so you have that before you also. Any questions for Ms. Melder?
I have a question.
Go ahead, Mr.
Were
Shaw.
there any compelling reasons why this gentleman Sanchez jumped in the ring, other than just frustration?
Well, he claims that he was jumping in the ring because his fighter was underage and he wanted to protect him in the situation, but the video shows him clearly going straight to the referee and arguing with him. Never once does he even look at his fighter. Mm-hmm.
And enforcement is recommending to accept the PFD?
Yes.
Because you originally asked for a $7,000 penalty and revocation. The PFD is for $5,000 penalty and 1-year probated suspension. You're
That's
okay with
correct.
that?
Yes, we are.
Chairman, I'm ready to make a motion if there's no
Any other questions? Mr. Shaw?
Okay, I'd like to make a motion to adopt the PFD as presented, suspend and probate the second license for 1 year and assess a $5,000 fee.
We have a motion?
Second.
Second. All in favor signify by saying aye.
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 Those opposed, motion carries. Thank you. Mr. Thielen. Tibor Katana. Is anyone here representing Mr. Katana or Katana? Go right ahead.
Good morning, Commissioners. My name is Trevor Thielen, and I represented TDLR at the SOA hearing against Tibor Katona, where the department presented evidence that Mr. Katona offered unlicensed electrical work during a sting operation conducted by the department in Katy, Texas in 2014. The ALJ found that Mr. Katona submitted a bid to install electrical outlets, ceiling fans, and electrical wiring to an undercover department investigator without the required electrical contractor license. The penalty matrix for this violation, which was a Class B violation when we alleged it, states that the range of penalties is $500 minimum up to $3,000 maximum. With this range in mind, the ALJ found this violation to be serious and that a $2,000 penalty would deter Mr. Katona from committing violations in the future. The department agrees that a $2,000 penalty is appropriate for the specific facts and procedural history of this case. I recommend you adopt the PFD as written. Do you have any questions I can answer?
Any questions, Mr. Thielen? Motion to be in order?
Is there anything from their side? No one else is here?
No.
Mr. Chairman, I'm ready to make a motion.
Please.
This is absolutely something that's very serious when you do electrical work that can cause property and health issues. So I would say I'd like to make a motion to adopt the PFD as presented.
A motion to adopt?
Second.
Second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, sir. Let's move on to our motions for rehearing. I believe we do have Eric Shalev. Is that right? Have a seat up here. Della.
Morning.
Go right ahead.
Commissioners. I'm Della Lindquist, Deputy General Counsel. Good morning. The first case, Eric Shalev, is a default, it was a SOA ALJ, determined the case, and you adopted the Commissioners, the PFD without modification, assessing a $1,500 administrative penalty for not providing auction records to the department. The motion for rehearing does not allege any error. It simply requests a reduction in the fee, which we recommend denying the motion for rehearing.
Any questions for Ms. Lindquist? Mr. Shalev, just kind of so you know, before we begin, the motion for rehearing is only ability for you to be able to talk to the commissioners about where we erred and come into our decision. We're not allowed to retry the case. That was at the ALJ portion or the SOA hearing. And then if it came before us for an appeal to the PFD, you had the opportunity then. At this point in time, we can only take in consideration where we erred in making a decision unless there's new evidence that's been brought forward that was in the SOA hearing that was not considered. Those type of things can be brought in at this point in time, but we cannot retry the case. If you don't mind, state your name for the record, please.
Yes, my name is Eric Shalev.
Go right ahead, sir.
First of all, I'd like to tell you that all the records, it was obtained to them. It was not obtained on timely matter because on August 26, 2013, a severe accident with a lady which ran over me on a car accident, left me with 14 broken ribs, and I was hospitalized for a long time and laying in bed for a long time, which is still affected me. Okay, during this time, okay, my property was sold and I had to store all my records and all my inventory into a storage facility. And I finally found out that the request from the department for my record, I did all the best to relocate them since it got lost and some it was of the vaccine was missing. I then submit all my records which I found at the next day. However, the department accepts my records and never claims any additional records which could be obtained by special services or by any methods of delivery. Based on past years, the records that was requested from the department, those documents requested never was, it was sufficient enough for them, and they never asked me any other questions based on past years for any kind of request documents. So my understanding was that it was fully satisfied and compliant. To finalize, the accident was a big effect and to get to the department all the records on timely and full accurate. The additional documents, if they did request it, if there was any need, it could be requested on the last hearing, if they did ask. But since for the past years they never asked for it, they were satisfied with the documents that we gave them, I felt that there was enough and satisfied to them. If they did want it, or if there was any issues, I could subpoena them, I could obtain them, and I can still bring them if they do want it. It shouldn't be any problem. But we did the best we can to get them based on my physical ability to get them. So over the past 10 years, I did the best to comply with all the requests from the department, and it would be very hard for me to get the first violation because We do the best we can to comply and not to have any kind of effect in any kind of future in our licensing. I believe there was no any violation. It was made intentionally, and because all the records was given to the department at the best of my physically ability and knowledge. Just consider that a 14 broken ribs and laying in bed for a long time will definitely affect you or how you're acting. Those documents can be obtained if they do want it. If they want the records from the hospital, I'll be more than happy to submit to them. And some of the records was relocated in different places. I could not have control of them. However, every document that they did want it, or if it was not satisfying enough, I could definitely give them if they did want it. I was believing everything is fine, and they was fully understanding. Please reconsider the motion that we filed, and I believe that if any more records that they would like me to submit them on that day, it could be obtained, which is still, I'd be more than happy to. But if we don't know that you may need it based on the past years, that they will ask for all the records, and I was giving them all the time, whatever they want. They never asked for
When
this.
were you in the hospital?
Yes, sir.
When?
In August 26, 2013, in Memorial Hermann Hospital.
Okay, but these allegations occurred in April, is that correct?
Yes, sir. It was before that. And I saw
When did you get out of the hospital?
a week later.
So you were in the hospital for a week?
A week.
Did you
and
receive notification and information from the department?
I could not go to my mailbox. They changed my mail. They switched my PO box. I could not get any information.
Did you change your address with the state?
Yes, we did.
You changed your address?
Yes, sir.
So we had your current address,
Absolutely.
even during that time?
I'm sorry.
Even during that time? When did you change your address?
Whenever I moved out from this property.
Okay, so you did receive our you did have a valid address and notified TDLR of that address?
Yes, sir. Unfortunately, the mail was given to the wrong PO box, and in fact, they closed that post office, and I was not even aware of this. And all the mail just relocated to another post office, which I believe a picture can be a record of this. I can bring it to you if you do wish it.
Your permanent mailing address on file is 1200 Post Oak Boulevard, apartment 2205 in Houston?
Yes, sir.
And then the latest correspondent we have is P.O. Box 7789 in Houston?
That's exactly what's happened. My PO box was changed at that time.
But that was in 2015, wasn't it?
The one?
That was in 2015.
Okay. When I moved from the property, I changed the address exactly to the address which I could get all the mail at that time. Unfortunately, the post office put it on the old PO box, all the mail, and I could not get any mails. And when I went there, when I finally got all this, they gave me a big pile of mails that was it was intended to give it to me, but they put in the wrong PO box.
So how did you know that there was some allegations against you?
Well,
Are you telling me that you received some of the mail but not all the mail?
After I found out that I'm okay to get up from my bed and get my life together, I
May
went
I
to
say
the PO
something?
box.
Yes.
I'm sorry, but the issue of the mail is not as relevant as maybe it appears. He had a hearing and all these issues were discussed, so I can discuss that when he's through.
If I did not get the mail, how could I go ahead and get it? I mean, I went down
No,
there.
my question that I had, that I asked you, did you receive some mail from TDLR? About the allegations and everything?
As soon as I get that mail, as soon as I saw it, I called them up immediately, and I get them all the records in the next 2 or 3 days.
Well, but it says in here, according to your testimony, that you gave some records, but not all the records.
Exactly, what I
So
found.
you didn't give them all the records.
I gave them all the records based on the past years that they was in. They taught me, they teach me that those records is sufficient enough, which is everything that was related to the particular cases which they're asking. They asked for a different records from all the other time, and I did not know about this. If I knew that, I could go ahead and obtain it, even though it wasn't down there at that time. It was not at that time. I could not relocate them because all this moving. And we're all human beings. We try the best we can to get what they want, and it shouldn't be a problem. If they still want those records, like I say, okay, if I knew that there's going to be enough a problem not to get them, again, based on all those years as which I get them, all the other one which it was not those records. So I would be more than happy to give it to them at that time. But I didn't know that. Plus I did not relocate all those items based on my injury, and all my items was relocated in other places. As soon as I saw that mail, the certified mail, I went, I called immediately, asked if it's still okay to mail them all the thing, and everything I found, I just gave them everything. And I asked them then if there is anything they need. They say no. I went to the hearing, and they come up with some other documents that it was not for the past years, which they're asking. Well, if I knew that, I could get them at that time, at least. But I didn't know that. But I still can get them if they do want it. I have no problem getting them all the records which they're asking. There's no reason why not.
Anybody have any questions for Mr. Shaliv? Anything else, sir?
I just like you to reconsider that. It's going to be the first one. If you're going to deny it, we do the best we can to enhance and emphasize our quality of how we processing things. If something is not intentionally was done, I don't think I was any kind of fault of doing, and I will get the records if they do request it from us. From everything that was missing, which they do need it, I'll be more than happy to just give me more time, and I will just get whatever they want else from that month, including call all the other avenues, which banks or wherever they want.
Okay, thank you. Ms. Lindquist?
I just wanted to add, and it's probably from the proposal for decision that you were looking at, but on page 6, in regard, the ALJ wrote, in regard to not providing the records requested by our investigator, respondent explained that he had to close his business when he was injured by a car. He claimed that he did not receive the documentation requests. Respondent stated that he did provide to staff through his attorney all the records that he had, but acknowledged that not all the records were available. So the ALJ considered all of this in coming to their conclusion.
May I?
No, that's it. We've closed the testimony.
And his attorney, he did have an attorney at the hearing, however, fairly recently his attorney no longer represents him, so that's why he's not here today.
Okay. Thank you. Any questions for Ms. Lindquist or Mr. Shalev? Thank you. You can have a seat.
Thank you.
Commissioners, motion to be in order.
I don't have a motion, but just a comment. Seems like there's some, can't put my arms around the chronology. It seems like there's some distortion in the chronology between what's written and what Mr. Shelby is presenting. And for that reason, I think I would be in favor of denying the motion for rehearing.
We have a motion to deny.
Second that motion.
Second. All in favor signify by saying aye.
Aye.
Aye. Those opposed, motion carries. Someone from the department will be in contact with you, just so you know that there are now judicial remedies that that are afforded to you through this process.
I'm so understand.
They'll contact you and let you know that you do have some judicial remedies in which to do this. Take it to district court if you so choose. But the commissioner has voted to not grant your motion for rehearing. All right, and someone from the department will get a hold of you. Yeah, please feel free. All right, let's move on to item number 2, Jeremy Smith, which I believe Mr. Smith is with us. Feel free to come and have a seat up here. Ms. Lindquist, go right ahead.
Okay, this motion for rehearing also is subsequent to a SOA hearing in ALJ in which you adopted the decision of the ALJ without modification, and you revoked his operator license and denied a renewal also for the operator license based on his criminal history. The General Counsel sees no error and recommends denying the motion for rehearing.
Any questions from Ms. Lindquist? Mr. Smith, I'm sure you probably heard what I told the previous individual.
Yes.
We can only take in consideration where the commission erred in coming to our decision. We're not here to retry the case, not a part of what we're doing at this point in time. So if you don't mind, state your name for the record.
Jeremy Smith.
Go right ahead.
I'm reading the email off of my phone, so I hope it's not a problem.
Okay.
All right.
And we, just so you know, we do have the email that you're talking about here. Is it the
same one I sent
where you're
you.
listing the various findings of fact and conclusions of law?
Right.
We do have that letter, just so you know.
Okay, so there's no need to.
You need to present
Well,
your
these are
case.
the errors that I found under number 4, findings of fact, stating that I remain under community supervision, and I'm no longer under community supervision. My term ended on March 20th, 2016. Also, number 5, under findings of fact, stated I failed to attend classes as required by probation, and that's not true because if I was not attending my classes, my probation would have extended, which it was not. And I also enclosed a log sheet showing my attendance record, and I can enclose an updated one showing my completion. Also, on the error in number 6 of findings of fact stated that my license will provide opportunity to commit the same offense. And I won't find that true because this is my livelihood. This is how I pay my bills. This is how I feed my family. So, you know, I wouldn't put that in jeopardy. Number 8 of findings of fact stated that I have not demonstrated the necessary fitness, honesty, trustworthiness, and integrity to hold this license. And I feel this is an error because I have enclosed in the first hearing docket 4 recommendation letters from people describing my character as a person before and after my offense. In those letters, it showed that I am honest, trustworthy, and that I have integrity. My fitness is showed by me satisfying and completing my probation period. Number 7, in conclusions of the law, I feel the evidence I did provide is not being taken into consideration. Prior to this offense, I've never been in trouble with the law, and I haven't been since then. I've always been employed with no lapses in between, even after my offense. I've attended and completed classes as required by my probation. If I was not attending my classes, I would have went to jail or my probation and/or would have been extended. Neither happened. As I said, I included the 4 recommendation letters showing my character. I've not been in trouble since then. All costs, fees, and fines have been paid. Number 10, conclusion of the law is an error because I've shown I'm fit to be licensed. I'm no longer on probation. I attend all classes for rehabilitation, and I have recommendations to prove that. So that is all that I have. I just would like to have the opportunity to keep working and to provide for myself and my family.
Any questions for Mr. Smith?
Yes, I do. Mr. Smith, one of the allegations is that you're not fit to hold the license, and then your counter to that was that you wouldn't put your family in jeopardy by losing your livelihood. But isn't that what you did when you committed the offense anyway?
I did. That is true. I wasn't taking that. I didn't think about that at the time. I mean, the allegations are serious, I understand, but, you know,
Are you a registered sex offender, sir?
No, I never was one.
You know, I worked a number of years in sex crimes, and they always had some justification or rationale why they were never at fault. And I get that same sense from you, in a way.
No.
Your letter takes item by item, everything that we're alleging, and turns it around. That you've not done anything, and we're at fault here, and we made a mistake there, and this isn't right here. It just really causes me some concern.
No, so I take full responsibility for what I've done. If my letter showed that I'm taking the facts and twisting it around, that is totally not my intention. I take full responsibility for what I did.
You made a statement here that says, number 4, stating that I remain under community supervision. I am no longer on community supervision.
Right,
This was at the time of the PFD that was presented to us.
right.
Were you under community supervision at that time?
At that time, I was.
Okay, then you see what we're talking about, you're distorting it, you're turning it around. Because when the PFD was presented to us, you were under community supervision.
What was the date
You
of
may
that?
not be now, but
What-
you were then.
Was it before the March 20th?
It was March 9. Right?
True.
I think that's where Commissioner Butler's coming from. You're taking these findings of fact and conclusions of law, and you're twisting them.
I'm just trying to defend myself.
I understand, and you know
that's all.
what?
I'm
You
not
should
trying to twist
defend
it.
yourself.
You know, I'm
I
trying-
completely understand that, I'm with you on that.
And the truth is usually the best defense.
All right. Have I lied on anything? Because I'm not trying to twist it around. That is not my intent. That's not my thought process of trying to twist around. I'm just trying to
So
make
how
a
do you-
case for myself.
So how do you explain, even just this first one, I'm no longer under community supervision?
Well, I'm not.
That's
As
not
of
what-
today, I'm not.
That's not what we're talking about. You weren't under community supervision as the date that you wrote this either.
Okay.
But at
well,
the time the PFD was presented, because that's when the PFD was done.
Okay.
So when the PFD was presented, that was when all of these facts were in place.
Okay, I understand. Well,
So
what
that's
about
what we have to do base it on.
what about me not attending classes?
According to the ALJ, that's what she found. Understand that the ALJ is one that presented this to us.
Uh-huh. Well, I mean,
TDLR defended this in front of the ALJ. Were you there at the SOA hearing?
Yes, I was.
Okay. So you were there also and you saw it. You witnessed it all.
and it wasn't true at the time.
But the
I
judge found
present-
it to be sufficient and found it to be true. So in the process of that, she put that in the PFD. Now, again, we're not here to retry the case, but the ALJ found sufficient evidence that stated that she had not completed classes. I don't know what to tell you, other than the ALJ said that.
But I was attending my classes. If I wasn't attending it, they would extend the probation.
Well,
Like that
I'm
was
just-
a mandatory that I had to do that, and that's exactly what I did. Now, just because my probation officer at the time said that I wasn't attending classes, because the class they say I missed, I made up. But I attended all my classes. If I wasn't attending my classes, they wouldn't let me off probation. That is the thing.
Mr. Smith, can I ask you about your offense? Tell me about the fact and the context of your offense.
You would like to know what happened?
Yeah.
I exposed myself to a woman in the parking lot of my vehicle.
What time of day was it?
It was, I don't know, in the morning,
How early?
maybe 10.
Mr. Shaw.
Mr. Chairman, we deliberated this case on March 9th of 2016. What has been presented to us, and this is just for the commission, or what I'm reading, and maybe somebody can correct me, Counselor, maybe you can correct me, but I don't see any prevailing evidence that justifies a rehearing. Can somebody otherwise tell me if I'm reading this differently?
That's exactly what I read.
We were recommending denying the motion for rehearing for that very reason. He brings up basically, he disagrees with some of the findings and conclusions.
Understood.
But he does, I could direct you to page 4 of the PFD. Mr. Smith testified on his own behalf, although, yeah, he admitted that the records indicate, Mr. Smith admitted that the records indicate he has failed to attend some of the classes required pursuant to his probation, but asserted that he made up the missed classes. So there doesn't appear to be any hard evidence that he made those up other than his assertion.
But this doesn't stop Mr. Smith from coming back to TDLR for
Applying for a
his-
license.
His new licensure, I think and if I recall correctly, the argument that the commission made was that it was a little too quick since the gentleman was on probation, am I correct?
I believe that's correct, if I remember correctly.
He has to wait at least a year from when the order would become final, which would be today if you denied his motion for a hearing. So he would have to wait at least 1 year from June 22nd, 2016 to reapply.
Mr. Smith, how old are you?
33.
33? You're still a young man. And for some reason, your life's not working out. And you need to start asking those questions. Why?
Well, so my life is working out. I'm currently employed. I'm stable. I'm able to provide. I mean, moment.
You're sitting before us asking for your license. You see, this is what I mean. I mean,
Okay.
everything in your mind is rosy. But the rest of the world around you is saying, you've done something wrong, and you're about to lose your license.
Okay.
And in your mind, life is working out. And in my mind, I'd be crying in shame if I were in your shoes. I'm not
I
trying to
already
beat
have.
up. I'm not trying to beat up on you.
But I already have.
I understand that. I understand that. But then you come before us and say, you guys are wrong, you guys are wrong, you guys are wrong. I feel like I'm talking to a wall here. You know, take what you can from what I've said, and then just leave the rest. All right?
For the record, sir, I'm very receptive to what it is you're saying.
Okay.
So,
I'm worried about your future. I'm worried about your soul. Good riddance to you.
Riddance?
Anybody have any questions for Mr. Smith?
You said you're currently employed?
Yes, sir.
Where are you working?
At Maestro's Barbershop.
Okay.
Any other question for Mr. Smith? Any other parting comments, sir? Thank you. Feel free to have a seat. Commissioners, motion to be in order or further discussion?
Make a motion that we deny the respondent's motion for rehearing.
We have a motion to deny. We have a motion to deny.
I'll go ahead and second that.
Second, all in favor signify by saying aye.
Aye.
Those opposed? Motion carries. The staff will be in touch with you, let you know what your other remedies are. As you heard me say earlier, there are additional judicial remedies that you can follow in the event that you want to go through district court. Okay? Thank you, sir. Thanks for being here. Let's go on to item number 3, David Sanchez. Is Mr. Sanchez here? Come on up and have a seat, Mr. Sanchez. Ms. Lindquist.
Okay. This case and the rest of the cases today on the motions for rehearing were default orders. Mr. Sanchez asserts that he did not receive the NOAV. Our records show that it was mailed to his proper address. He alleges that because he had a previous claim or previous sanction against him that he was confused, that this might have been the same one. There was, several years ago, a case against him which he has satisfied $1,000 for some unlicensed activity, I believe. But these were two very different cases, two very different years, so there really shouldn't have been a confusion. So we recommend denying the motion for rehearing.
Any questions for Ms. Lindquist?
I have a question. So when they did the default, and I understand the difference in price when it's a default, that you'll go up a lot higher, but I'm trying to figure out, was this basically a Craigslisting like we had earlier today?
Yes.
And that penalty was what, 2?
For this particular case?
No, the previous one.
The previous one was, the old case was $1,000.
Not of his, I'm talking about the previous case today. We just heard one on Craigslist.
Oh, one of the
One of the other
contested
state-
cases?
Yes.
I don't remember what that penalty was, I'm
Let me
sorry.
look it up real quick. Okay, thank you.
Mr. Thielen.
Trevor Thielen with the Enforcement Department. The case you're talking about was Tabor Katona. That was an electrical case. That was also alleging a Class B violation. That was a $2,000 penalty for a bid that was offered at a sting operation. This is an AC case. It was alleged as a Class C violation. We increased the penalty matrix a ways back to move unlicensed activity in AC World to Class Cs. The range of penalties, I believe, is $1,000 to $5,000 in the Class C AC range that applies to Mr. Sanchez's case.
Okay. And this is his second time, Della?
It apparently is, but we alleged it was his first,
Okay.
so it was based on first.
And then, Mr. Thielen, the other case, what was the range of punishment when we gave him the 2,000 for the Craigslist violation?
The range was $500 to $3,000. I'll note also, this commission in December changed the enforcement plan in the electrical world to more closely match this AC one. And so now unlicensed is a Class C in the electrical program as well as the AC program.
Okay.
But we were going under allegations that were started under the prior enforcement plan for electrical on that case that you heard earlier today.
Okay.
Thank you.
Brad, can I ask you, if I made a motion to accept the PFD but to amend the penalty, do I need to find other basis for this to state on the record, or would it be better just for me to move to grant the motion for rehearing?
This is Brad Bowman, General Counsel.
PFD today.
What you could do, if the commission is inclined to do that, is to deny the motion for rehearing, if you reject the arguments that the respondent is making, and then to modify the order to lower the penalty and maybe explaining the rationale for that, why you think a lower penalty is appropriate. But that is an option.
Okay.
And just a reminder, there's no PFD today, it's a default order. But
I'm
you still
sorry.
could modify the executive director's default order.
Gotcha. Okay.
Any questions for Ms. Lindquist? Additional questions for Ms. Lindquist? Mr. Sanchez, I'm sure you've probably heard of me before. We can only consider those items. Well, this is not a case, so you got to bring forward some new evidence as to why we should consider this motion for rehearing. So, if you don't mind, state your name for the record, please.
David Sanchez.
Go right ahead, sir.
No, I just wanted to say that I'm still unemployed. I put the resume on online. It's on different websites and I have it online. The reason I was just checking that it was the same case. That's the only thing I was letting them know that I took care of it. I haven't bid it or anything like that. Like I took away the ads and everything. All I have is the resume, and that's the only thing I have. I haven't bid on any jobs or anything like that. That's trying to continue, and I'm trying to go with the contractor's license and follow through with that. And that's it.
Okay. Any questions for Mr. Sanchez? Thank you, sir. Have a seat. Commissioners, the motion to be in order?
I would move to deny the motion for rehearing, correct? And then, but move to amend.
Yes, and modify the
Modify,
penalty.
right, to $2,000.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye. Aye.
Those opposed, no. Motion carries 4-1. Someone from the department will be in touch with you. Basically what's happened is you're not going to get your rehearing, but they're lowering the administrative penalty down to $2,000. Okay? Let's go on to item number 4, Joseph Starks.
Okay, this is also a default order, and it may appear confusing to you because similar names of the barber shops and very similar locations. However, a review of the record assures me that we did send the NOAV and all the notices to the proper people at the proper time, and the proper shop was inspected. So I know that the respondents are alleging some confusion or muddying of the waters about the various shops and ownerships of King of Cuts 2 or King of Cuts. We recommend denying the motion for rehearing.
Any questions for Ms. Lindquist? Is there anyone here representing King of Cuts 2? Commissioners, the motion to be in order?
Motion to deny the rehearing.
Second.
Motion to second. All in favor signify by saying aye. Aye. Motion carries. I'm sorry, those opposed? Motion carries. Item number 5, the Eureka effect.
Okay, this also is a default order, and Ms. Runnels' motion for rehearing again alleges that she did not receive timely notice of the NOAV. A review of the record indicates that several of her notices were unclaimed. She alleges that there were some issues or problems with the Postal Service. She also claims some letter that she got was postmarked March 8th of 2016. I'm not exactly sure what that might have been. A review of the record shows that the NOAV and all the notices were sent to the appropriate address. The letter that she did apparently go pick up finally on April 26, 2016 was the default order. I believe I had put in there that it was the NOAV, but it was the default order. So she went and got that. So she's seen the default order. Apparently she's never read or seen the NOAVs. She claims there was some mix-up at the post office. As you know, when we mail it to the appropriate or proper address, it's a rebuttable presumption that it went to the right place. If you believe that she has presented some credible evidence to show why she wouldn't have gotten it, you could find that and grant the motion for rehearing.
Recommendation by General Counsel is to grant the motion for rehearing.
Our recommendation would be if you believe sufficiently that she has led you to believe that there were some issues with her postal service and she didn't get the NOAV mix-up at the office, then you could grant it.
Was her address changed at any point in time? Was it still the same address?
Yes. I mean, no, nothing has changed. She claims that there's some postal mix-ups at the office. There's a scintilla of evidence when she got something postmarked March 8th. That could have been some kind of mix-up. I can't trace that to any particular letter that was sent. So there's that. But we sent it to the right address.
And the
and they
address
went
has not been
unclaimed,
changed?
And her address has not been changed.
It went unclaimed, but now all of a sudden she got a letter on March the 8th.
She went and picked up a letter on April 26th that was the default order.
April 26th, it was dated March the 8th. Is that right?
Now you're confusing me. No.
That's easy for me to do.
We had sent the default order was mailed to her on April 13th, and for some reason, she finally picked it up on April 26th. I think she was probably, I believe, she was trying to renew her license, and because of the hold, it wouldn't let her. And then she saw there was a notice at the post office, and she called up here, and we told her, you know, or someone here told her to go pick it up, and she did, and it turned out to be the order.
So you sent a letter in March, or April, what day was it again?
We've sent several notices. The way it works is we send a notice of violation, giving you time to look at the allegations against you and ask for a hearing or settle. If we don't hear from you, then it goes to the default process. We send another notice called a notice of default, which again gives you some time to ask for a hearing or pay or settle.
Okay.
She never responded. Then at the very end, after that's exhausted and we haven't heard from you or from the respondent, it will be defaulted, and our executive director will sign a default order and mail to you. And that's what you appeal from, is receiving that order. She apparently received the order. She's claiming she never received any of the other notices. All we know is that they went unclaimed. We sent them to the right address. They came back here unclaimed. So she didn't pick it up for whatever reason. So I will agree that she didn't read the allegations against her, but we didn't do anything wrong in that process.
Yeah. Any other questions for Ms. Lindquist? Is anyone here representing the Eureka effect? Commissioners, a motion to be in order?
Motion to deny the rehearing.
I'll second that.
We have a motion to deny, and all in favor signify by saying aye.
Aye.
Those opposed?
Aye.
Motion carries 4-1. Move on to item number 6, Touch of Beauty.
Ms. Chavez, this is a default order, and Ms. Chavez alleges that she and her employee have corrected the violations in question, but she does not allege that she did not receive our notices. She doesn't allege error. So we recommend denying the motion for rehearing.
Anyone here representing Touch of Beauty? Commissioners, questions for Ms. Lindquist or a motion to be in order?
Out of curiosity, I have a question for Ms. Lindquist. Do we know if she actually has rectified her violations?
I do not know that for a fact. She's alleging that.
Wish she would have been here. Okay, I'll move to deny the rehearing.
We have a motion. We have a motion to deny?
Second.
Second. All in favor signify by saying aye.
Aye.
Aye. Those opposed? Motion carries. That takes care of all of our motions for rehearing. Let's take about a 5 to 10 minute break, which allows our staff to go ahead and exit the premises, which, other than doing it in the middle of the meeting. So, let's go ahead and take a short break.
Make it look personal?
Exactly.
It's
Yeah,
about
so
you.
it's not personal? Strat plan. I'm not sure who's going to be doing the presentation.
Mr. Chairman, Commissioners, Brian Francis, Deputy Executive Director with TDLR.
To be the new executive director beginning September 1,
Yes,
2016.
my
That
mom
needs to
told
be your
me-
new title.
It's just like really long.
Yeah, Deputy Executive Director to be the executive director beginning September 1, 2016.
I can deal it. I can handle it. It just doesn't fit on the back of the shirt easily. But we'll make it work. We'll make it work.
I cleared my mouth.
You ready? Okay.
Brian was gonna have me start, and I just taken a bite of trail mix, so that I had to chew before I could start talking. And as you're talking about the new executive director to be, that we've been going through an interesting handoff, because there are decisions that are having to be made by the executive office that are gonna carry forward into the future. And what I've been trying to do is step back and say, all right, Brian, this one's your decision. I'm not gonna mess things up on that. So, in looking at what we've got just for the cover, that we've had for the last two strat plans, that smaller, smarter government, because we've been bringing that forward to the legislature to really point out what we were trying to do to really be streamlined. The discussions were that the legislature knows about our smaller, smarter government, and we needed to really look at a new title for that. And Brian worked through that, and he had a focus group look at it, and it willowed on down so that smaller, smarter government got left on the cutting room floor. And it's the bold direction for tomorrow's Texas, which is really appropriate with, we've got a new executive director that will be bold and taking over. So I think that it all fits together just beautifully. The process was really a good process. And Chairman Aris-Mendez, last week when we were listening to the IDEO presentation, the case study that was done, and how they got the input from everybody without any judgments, and put the input up on the wall, and then came and voted on those items to say which one's the most important. All of that just rang true, is that that's what we've always been doing with our focus groups for strategic planning. And we've been on the right track, and it's nice when you get validated by that, to say, yes, this has been done the right way. We did that for this plan. We got input from lots of different areas, but a core portion of that is that focus group with the internal, with the employees doing that, and also with the external, the licensees and the public that we affect. So this plan is a fantastic plan. It's under new direction from the governor. It's given us a new format for that, and I think that we've got a more focused plan because of it, instead of the old plan directions that we had in the past. We don't have to have some of the filler that we had. It focuses on what we can do better, what are the redundancies, what we can do without, and I think that we've really been able to come up with an excellent product for that.
Bill, I appreciate that. This is an exciting plan, as Bill said. A lot of folks contributed to this. The internal focus groups with all of our employees on the draft teams, the editing teams, the evaluation teams. We build our plan from the bottom up. Stakeholders having the external focus groups around the state, doing Facebook surveys, the web surveys to get the input. The biggest challenge these days is evaluating all the data. How do you synthesize and go through all that information and come up with less than 20 pages in a strategic plan? The bold direction is set by the executive branch. Governor Abbott has set a bold direction for us. Just in the instructions alone, he said it's going to be different, and it felt different. It even felt uncomfortable because you're used to something, and now we're doing something different. But what came out of it is something better. When you look at our plan, and particularly the impediment and redundancy section, it's powerful. It's what government should be, which is less. The number of impediments and redundancies that we identified, whether it's offering and identifying programs that can be deregulated, whether it's removing impediments for a person getting a license, whether it's residency requirements, examinations that treat out-of-state applicants different than in-state applicants, removing criminal and civil penalties that should not be there. Our licensees shouldn't be under the threat of a criminal violation for an administrative violation that shouldn't be there. And so we've got that in the plan. The 5 goals, that was something exciting to work on. We have 5 goals that will drive us going to 2021, and we start off with about 60. All the directors were involved in coming up with the goals, and we met over about three meetings and whittling it down to something that's actionable. And every employee in the agency is now going to be able to see themselves in that goal. We kept our core values because they are who we are as an agency. We've redefined them, but we didn't change what they mean to us. One of the projects that Bill's been working on is meeting one-on-one with employees to have them identify their purpose and how it connects to TDLR's core values. That's going to continue. The smaller, smarter government is going to continue. And you look at that impediment section, it continues aggressively. There is a lot of information that's going to allow us to be smarter. Some of the provisions that come over from the new programs, for example, with the hearing fitters. To be a hearing fitter in Texas, if you are a corporation, your CEO has to hold that individual license. If you're a partnership, all your partners have to hold that individual license. That's a barrier. It's a barrier to entry. That's in our plan to get rid of that. Residency requirements for an out-of-state license. You can't live outside of Texas and hold an orthotic or prosthetic license. We're saying that should change. You shouldn't limit the folks that are right there on the Arkansas-Texas border. So if someone lives on the Arkansas side, they can't be an O&P in Texas and just drive across the street in Texarkana. So there's a lot of great things that are in there. We've recommended that we start conversations with the Texas Real Estate Commission about them maybe taking over the property tax consultant program, because nearly the majority of our licensees are real estate brokers. So there's already this overlap that exists. We recommend that there's a conversation between the Real Estate Commission, the Department of Insurance, and TDLR as it relates to some of the overlap in the service contract provider world or the warranty world. They do home warranties, we do service contracts, and sometimes the appliances, depending on who installs it, gets blurred. And so there needs to be a conversation about how we can improve in that area. The plan is exciting. We will meet with our staff tomorrow in a town meeting. Once the commission has an opportunity to vote on it today and roll it out, we will meet the deadline for getting the plan posted on our webpage on June 24th, which is Friday. We will meet the deadline for getting the plan submitted to the governor's office and the legislative budget board. This bold new direction includes just the formatting of it. We went landscape, and that's a big difference.
And we need to compliment Rhonda on that.
Oh yeah, I was going to get
That was
there.
her
I mean,
input.
Rhonda did an amazing job of designing this, of staying up till 3 and 4 in the morning. I've seen the emails to prove it. There is so much of her heart and soul in this document. I just want to get commended for that. She did a great job. We've got pictures and images. Speech.
And Rhonda was at the office typing last-minute corrections and printing this out at 6:30 last night. And we know that there was more pleasant things to do at 6:30 than to be typing corrections to the plan.
Yeah, I got an email last night.
Mr. Chairman, there's so many folks we could compliment, and we're going to definitely acknowledge them tomorrow during the town meeting. But I do need to point out Jeff Kopis and Gina Garcia Reardon. They were invaluable in helping us take a different direction in how we format this document. The drafters, the writing you saw that in the version that we provided to you. This is some of the cleanest, simple, plain talk writing that you'll see, and it makes us proud. We will be bold in comparing ourselves to other folks out there. TDLR does not shy away from competition, and we see this as competition. We see the agency setting itself apart. We were freed up by making it completely electronic. There's so many more things we can do with the layout and the presentation of the document, and we're going to take full advantage of that. When you see it on our webpage on Friday, the plan itself will be separate, and so that's less than 20 pages. And then you'll also have the opportunity to go to the schedules if you want to. But when they see our strategic plan, it's going to be that very quick, direct look at what the agency's doing. I want to commend the commissioners that gave us feedback. It is woven throughout the document. It is also woven into my mind of some of the things that I need to be cognizant of as we move forward in thinking about the agency in a year, 3 years, 5 years, and 10 years. And so those things are, they were invaluable. We are already having discussions about what TDLR tomorrow will look like. So very exciting. We would ask the commission, if there are no questions, we'd ask the commission to vote approval of this with the ability of the staff to make any editorial formatting or non-substantive changes. Rhonda's still doing her final edits, so I can't stop her from looking at it. But I'm available to answer any questions.
Commissioners, any questions or comments to Bill O'Brien, or Rhonda in this case? Real quickly, and I'm not sure if it needs to be a part of the strat plan or if it needs to be part of our legislative agenda. The comments made by our presenter in the public comments, have those issues been considered? Have they been addressed, or was it a part of what we were looking at, or is it new information that we received that we now need to take a look at? Real quickly, I mean, how are we in that particular program, actually any additional programs that we find errors coming in or something's coming in?
We're going to be open to that dialogue. Obviously, it was very powerful, what he presented to us. The approach we took on particularly the new programs coming over is that we were not going to delve into the scope of practice issues. That is, it's an important discussion, but it brings in the different competing medical groups. So we've got to be aware of that. We do know that their statute only requires voluntary information. 2 sessions ago, in the midwifery program, there was a bill introduced that may make the capturing that statistics mandatory. One of the things that he talked about, though, we could not create statutorily if we wanted to, which is he really wants a national registry created to capture this information. The most we would be able to accomplish in Texas is requiring our licensees to submit information somewhere, but the somewhere doesn't necessarily exist as a national registry, nor could we compel all the other states to participate in that. So some of the things that he wanted to accomplish, we could probably inch in that direction, but we wouldn't be able to fully identify, a group. So Arello, which is a real estate licensed law official, all the state agencies participate in that, and they submit their data there. You also see what's in the medical boards. The midwifery industry is not that mature in that regard in terms of having a national registry. There are national groups, but all the states don't necessarily participate.
Well, and I understand that, and as you said, the relative age of it, I think that, if Texas could be a leader in that front to help create a national registry, I think would go a long ways. You mentioned some of those that exist, but I think there's, as pointed out to me, even animal breeders, and they've got some national registries they've got to be a part of. So I think that the importance of what is done in this particular industry, and there are others. I mean, it's just simply that we've had this presented to us, which was a powerful statement made. So I just think that it's brought it to the forefront. So just some of the things that we want to take a look at and put either as part of a legislative program or keep it kind of on the front burner. What I don't want to do, and I would encourage the commissioners also, is to continue to ask these type of questions, and let's not let it fall by the wayside. I know that we've had some issues in the past that we've let get stale, and I don't want that to happen in some of these cases. So let's continue to have that conversation and push forward, and I would encourage the commissioners to continue to ask questions to find out where we're progressing and where we're at on some of these issues. Yes, Commissioner Butler, please.
I'd like to echo some of what the chairman just said. If there's not a national registry and we're tilling new ground, then let's make it the way Texas wants it, because as other states look to create these registries, they will look to Texas because we're leading the way. So let's make it the way it needs to be. Let's look at the outcome that we want. And nobody does that better than this agency. At strategic level, let's look at what we want it to be. Because as we start taking on these licenses that deal with life and health issues, it becomes much more prevalent. The impact is much greater. The testimony of the gentleman this morning, Mr. Garback, these are going to be the issues that we're dealing with going forward. The health of somebody losing their hearing, prosthetics, The last thing we want to do is do any damage. So let's address these before it ever gets to that point, and let's be as transparent and forthcoming with as much information as we can to the public that we're here to try to protect. Because that's the last thing we want, is somebody to say, you know, this information was hidden from me. And nobody does that better than us. You know, in the marketplace of governmental services, TDLR has won. We are continuing to win. But let's not be arrogant about that. And let's say, you know, we're still striving. Let's continue to strive. And just because we're winning in the marketplace of governmental services, it doesn't mean we should be complacent, right? And so just, you know, we've done a great job, such a great job that they're giving us these licenses now that deal with human beings, directly with human beings, not through an air conditioning system and not through an electrical system, but directly human beings. We're impacting the life and safety of Texans. And so we need to be on top of our game. And maybe everything was practice getting us to this point. And now we're the A-team, okay? So this one just concerns me a lot. What we heard this morning is impactful, and I'll be thinking about this for a long time. So.
Commissioner Yurko, go right ahead.
I just have a quick question. Where do we stand on the timeline-wise? Like, when will these rules be put forward to be adopted?
The plan for all the items that are in the impediment section is to begin drafting drafts for those for legislative purposes, and then working with the governor's office and different key stakeholders in the legislature, and then January 1, seeing if there are bills introduced. So we're looking at a legislative session. They've got to pass.
Oh, no, I'm not talking about that. We got this from the last legislative session, the midwifery, right? Midwifery,
Correct,
however you pronounce
correct.
it. Okay, we got that. When do those rules, have they already been adopted?
Yes, you adopted them at your last meeting.
Okay.
And so
They become effective October 1.
October 1.
Okay,
And
that
we
really
made no changes in
concerns me,
scope.
because I feel like once it goes to October 1, if they're not in there, I gotta be honest, Tom, I'm a little concerned we'll never see them. Because what ends up happening is it goes to the advisory board, and then we may never see an opportunity to address these points. So that's what I'm concerned. We're now at June. I'd like to be able to do something proactive, that we actually address some of these concerns, because some of these really are major concerns to citizens in this state.
Commissioner Yurko, I share that concern. Most of the items, if not all the items that were addressed by Mr. Garbez, they're going to require statutory change. The law is the one that requires the voluntary reporting. So
The application, when you fill out the information for a
that
license?
stuff there, we're going to take care of that. I mean, that's
that can be
Department of State Health
policy.
Services. All of our applications have that question. So we're going to put the TDLR touch on the application stuff.
Okay.
But some of the issues he was talking about are really going to be statutory.
Okay.
And the approach that we took was, we purposely did not look at scope of practice issues because we do need to become familiar with those programs. We don't know enough about how they operate and their impact in the 9 months that we've been looking at the rules. We need to get them under our umbrella, learn them, and get a sense of it, because they are very different from anything we've ever dealt with. And so we purposely chose not to make scope of practice changes on day one with those practitioners coming over without knowing how they operate.
Is there a way in the future, when we vote on rules like this, in order to know what the public comment might be on them before we just summarily pass them?
Yes, on
receive
rule
those.
adoptions, the General Counsel's office will go through the comments that we received and say, yes, this comment was received about this and we agree with it. This comment was received and it requires a statutory change. We can't put it into the rules.
Right.
So they explain that on the
I
front
remember
end.
that. I just didn't remember that coming up if we passed this last month.
The rules that came out last month were dealing with putting it in TDLR, and the approach we take is to put them in TDLR's format and make sure they look like all of our other rules, to remove any provisions that don't have a statutory basis, to change the titles from their commission to TDLR, and to make process and procedural changes. But we did not delve into their scope of practice until they get here, and we talked about that for the first year.
Okay, but I guess I'm still trying to figure out, is what we adopted last month that you're just talking about, did it not have these details that would have addressed that we would have had, at least had knowledge of what we were voting on?
It did. It did. In the preamble for when the
And that
rules
was in
were
our
posted,
April 18th
as well as the preamble for the meeting where you guys adopted it, we included the process we were undertaking. We included all the comments and our responses to those comments. We included the information that was gathered from the 2, in some cases 3 advisory board meetings prior to, if there were folks that were coming to those meetings.
And then we had 0 public comment on those? Or did they
No,
have an
we-
opportunity?
We had
Yes,
public
they had
comment.
comment at the first meeting, during the comment period, as well as at the second meeting. And one of the things to keep in mind is that with the midwifery program, because it is so different, a couple of things that we're looking at is creating some forums to have the discussions. It will be something that no other state has. In most of the health professions, you have white papers and you have associations that have a lot of dialogue. The midwifery program was using their complaint process as the main vehicle through which they were learning the things, the ins and outs of how to do it. We want to create a better educational moment or forum for them. That's going to be different for the programs coming over as well.
Thanks.
Absolutely.
A couple of things. One, I'm being the rookie on this thing. I want to make sure. But I would tell you that just for my quickness, I like a follow-up to the father from us. I want to make sure that he, I mean, I think we owe him that, and that he needs to be informed as to how we progress with this. Second, the caveat I would oppose to you is we're operating at the speed of light in a lot of these changes, and I think that's fair, and I commend you. But sometimes at that speed, things get missed, and so I think there should be maybe an adoptive process. I mean, I look at some of the impediments that you have listed here, and one of them is eliminate criminal penalties and administrative licensing on those midwives or midwifery. And so, sometimes the sword gets too broad, and so sometimes surgery is needed instead of a chainsaw. So I just be cautious of that, I think, in that approach, because now we're delving into some. And third, I would tell you that we could probably tag along a lot of this health concerns that he had with the abortion legislation that's just passed in Texas, about having a hospital on call, registered doctors at that hospital that is now, I think, in front of the Supreme Court. So I think the mood and the temperament among the legislatures, we could parallel a lot of this stuff with that, because the birthing process that we're looking at here is probably akin to that same process. So we need to look at what's that done. And third thing I'll tell you is as many stakeholders and experts as, because I'm not an expert in this, right? The collaborative effort among the medical field, I think, is going to be key that we have when we diagnose what we need to do to change.
Absolutely.
So if you could put those into play, I think that'd be great for me.
We will.
Thank you.
Commissioner Shaw?
Job well done, Brian and
Thank
Bill and the staff. I think you guys have done a great job. Just a couple of pointers. I wrote down 5 items. I had some time to read the plan as crisp as it was last night. I've got 5 items that I had kind of come through, and I think I'm not going to dwell into the weeds. I'll let you kind of go back and figure that out with your directors. But very high level, 60,000 feet up. Number 1, your performance measures, make sure that they are measurable and valid. You're not just measuring junk. It's not just out there just to impress somebody, but measure it so that it's strategic for yourselves. It's like going out and working out. If you can run 2 miles, it's a great deal. You do 2 miles. You can keep noting it that you're running 2 miles every day. But maybe the goal is to get from 2 miles to 2.5 miles. When you reach that goal, you reach to the next goal.
Absolutely.
And so forth. I think your performance measures have to be measurable and valid, for anybody that's looking at it. It's not just how much data we're mining, but what are we doing with that data. The other thing is, I always get concerned, and this is just for everybody else that's in the audience here, I get really concerned with whether it's government or business that gets too big, too large, and loses the sight of its customers. TDLR has been known to be in with their stakeholders. We've been engaged with our stakeholders. Over the last 2.5 years since I've been on the commission, I've seen a lot of new programs that we've inherited. I want to make sure that it's just like having, your firstborn, and then you have your secondborn, and then you have your thirdborn. By that time you have your thirdborn, you've already forgotten about your firstborn. I want to make sure that we don't lose sight of our stakeholders with how large this agency is getting. That
that concerns me, and I want to make sure that we don't get disjointed with those that we have been serving. The third item is the facilities. I really am concerned about the strat plan not measuring our facilities. We have so many different places where our staff is sort of located or dislocated. Maybe this is time to start looking at creating a central location where all the staff is in one place. What I'm seeing is that each of your agency, within the agency, each of your directorships deal with each other. And I feel like whether you're off-site or out of town, whether you're, website, working from the home with all the new technology we have, it still creates a problem. The face-to-face can never be replaced with anything else. So I feel like we need to start looking at that. And then if we need to, we need to look at maybe kiosks outside of Austin, maybe with the population growth in Dallas, the population growth in Houston area, El Paso. Maybe it's time to create an off-site kiosk, where it's manned and where our stakeholders can walk in and deal. And I'll use an analogy real quickly. The grocery stores went with self-checking aisles, if you remember. Now they're going backwards, and they're going back and saying, no, sorry, that didn't work out. We still have a person that's checking you out.
Mhm.
And so that face-to-face stuff is not going to go away, and I really think we need to look at that in the strat plan of the facilities. The fourth item is looking around the corner. I think the strat plan didn't speak to that. I didn't quite grasp it. What is TDLR doing to look around the corner? Very important. Our business trends are changing, technology is changing, and it's changing at warp speed. Who knew that technology would go so fast and so far ahead? Who knows, there may be new licensures that we'll be dealing with in the next 5 years. I just feel like we need to keep that process going in looking around the corner. And then last but not least, I think there needs to be some mention about our human capital. This agency, like any other unlike any other agency, has tailored employees that are fitted for what they do. It's like buying a tailored suit. It's fit for this agency, period. So if you lose that tailored suit, you've lost your human capital. So as much mentoring as you guys do, as much succession training as you do, I think we need to be very careful about making sure that we keep harnessing that human capital here within this agency and not losing sight of that.
Mr. Shaw, I appreciate that. To address a couple of things that you've identified, I'll start in reverse. In regard to the human capital, when you look at Schedule D, the agency workforce plan, there's about 10 pages dedicated to that analysis of the skill sets we have now, the skill sets that we need, the gap analysis and how we're going to get there. It also speaks to the retirement age, the length of service. So there's a really good analysis that was led by our personnel attorney, Sharon Hamoya. In regard to the looking at TDLR's future and around the corner, one of the things that I'm going to make the responsibility of the Deputy Executive Director is having the strategic look on TDLR's infrastructure in its 3 areas. One is looking at the infrastructure for space and looking at it from 1 year, 3 year, 5 years, and 10 years. The other is looking at TDLR's infrastructure for IT. We have multiple licensing systems, and taking that same look of 1 year, 3 year, 5 year, and then 10 years. And then finally, the last one is going to be on organizational sustainability. Looking at our agency, not at the standpoint of years, but looking at it from today at 25 programs, in a year and a half at 32 programs, in a year and a half after that at 38 programs. And so I want to take a look at 32, 40, 45, and 50, and just start visioning what does that look like, not even trying to figure out exactly what the programs are, but what does our organizational structure need to change to when we get to 40? How does it need to modify itself when we get to 50? And having somebody dedicated to doing that analysis, looking at Florida and looking at Colorado and looking at Pennsylvania, New York, the other agency or states that have large umbrella licensing agencies. So we are definitely, I'm hearing you on that to focus on that. And if you look at one of the goals, it is how do we increase the number of mobile apps one of the things that we've done in the past, and Bill's emphasized this, probably in one of our first strategic plans here, was that we want to have high tech so we can have high touch. We want to automate as much as possible so we can free up ourselves to have the conversations. And so the more we put online, the more we do with mobile devices, it is going to free up our thinkers to have those conversations and build the relationships you need to have in order to be a successful agency. So we won't lose sight of that, and we'll definitely throw some effort into doing that.
Thank you, Brian.
Right, and then I think one other thing that we discussed last week at the conference that Mike and I had gone to, that the millennials and what government agencies need to do to attract the millennials to service. And they had some really good ideas about that I think that that was a good discussion to bring back to Sharon so that we can start folding that into what we've got. One of the things that they were saying is that millennials don't stay in one job very long. They'll move from one job to another. And the thing to offer to them is to have other jobs within the agency that they can move to. And we've had that, and we've suffered a little bit about that because the division directors have been stealing employees from each other. And it becomes a joke that, oh, I lost somebody to this one, well, I'm gonna have to steal somebody from there. But that process has been a good process for us that really addresses that issue of the millennials wanting to have new things to do instead of being in that one position forever and ever, because they are not going to stay in one position looking for a pension. They want to be able to move and do different things. So I think that we got some ideas last week that we can start folding in, that we can start really having a good discussion about that, which will really make our human capital efforts a whole lot better, that we will be out there on the front edge where we need to be again.
You know, and that conference that we attended was, as Bill was mentioned, was very good. Also talked about data analytics and trying to figure out where we're at, but it was focusing on high technology also. And I think one of the things that we really need to start taking a look at is a mobile app in order to be able to reach out to our client base. And it was the state of, was it Wisconsin or Washington? Washington, that had an app that you could go out there and you could basically, in the state, be able to get any license that you needed. Of course, Texas is a much grander state, so it'd be a little more difficult. But it was a great app, and I saw that, and I was like, you know, that's where we need to be, that somebody can take that mobile app, log in, and they could be able to obtain their AC, electrical, you know, Cosmo, whatever they're looking at, and have all of that just at their hand. And if they're near a printer, they could print it out immediately and have it all right there once it's been processed, paid for. So I think, you know, moving in that direction is one of the things that we definitely need to start moving, the high-tech, high-touch, be able to reach out to them, especially as we talk about the millennials being out there, not only in our agency, in government, but also being out there doing the business. We need to be able to do that. One of the things that Commissioner Shaw mentioned at the very beginning was to make sure that our performance measures, that they're measurable and valid. It brought a story back. I had a friend of mine that decided he was going to start exercising, and he told me he started jogging 1 mile. That's great. A couple of weeks later, I checked on him, and he was saying, well, now I'm up to 3 miles. And then, you know, about 2 months later, he says, I'm already jogging 5 miles a day. And so I'm sitting there going, wow. The problem is that he was confusing 1 lap around the track for 1 mile. And so the measurement wasn't valid. So that being the case, you know, let's make sure that when we're talking about those measurements, I mean, I think that there's 2 things that we look at, and which is, of course, in the evaluation process, is that we have those tactical measures that we have, and then we have the strategic measures that we have. And we need to continue to push both those boulders up the hill to ensure that we continue to be a strong agency as we have been in the past.
One of the neat things about this process was the majority of the performance measures that we have as an agency, they're inherited. All the licensing agencies pretty much have the same ones. And so there's not a lot of flexibility or opportunity for us to kind of pick and choose. But when they added that section that we could create and develop our own goals, I mean, that was a game changer. Absolute game changer. And when you look at those goals, they really define what we want to do. It defines some of the things we're doing right now, but making a goal of constantly identifying bottlenecks making that a responsibility and a charge and something I'm going to measure the directors by. What type of improvements are you making on a regular basis? Christina's group came up with an outstanding one on enforcement, which is, and this body deals with it all the time. There's a difference between a paper violation and one that touches a consumer. But in our world, they're all pretty much treated the same, $200 fine here, that sort of thing. We're saying let's treat it like it's a DA's office, to where we are making choices about those violations that have a direct consumer threat and harm, and let's elevate those to the forefront, and not just get caught up in the low-hanging fruit of, oh, they didn't cross the T, they didn't dot the I, and that sort of thing. So there's some really fantastic goals that are going to transform the way we allocate our resources, which is going to transform the way that we regulate. And that's a good thing. That's that bold direction we're talking about.
Commissioners, any other questions about our strat plan? I've got one other thing. I do have a question that I was going to ask.
Was it on page 13, I think, Mr.
Beginning
Chairman?
on page 13, the statutory change to be removed and redundancies and impediments.
Yes, sir.
Did this, was this approved by Bailey by any
Yeah,
form or
this is
fashion?
one of her recommendations. I think Bailey can come to the table and speak on the issue of the deregulation of temporary common worker employers. Bailey, would you like to?
You can thank your dad for that, by the way. For those that don't know, Bailey is back there in the back. She's interning with us right now. So I have a feeling that her dad's gonna get the coach shoulder for a while.
Is she the one in the red face and white?
Yeah, she's the one in the red face and white shirt
Red
right
face,
now.
white shirt, okay.
So don't everybody look back there because it makes it worse. So,
Bailey, you're safe because the camera didn't turn to your direction.
Commissioner Figueroa, you brought up a point. In this go-around, is it your preference that we, in terms of moving with the speed of light, is it your preference that we remove the criminal and civil elements for midwives from this document?
For me to make that call, just this, I think.
We have the throttle.
Right. I would say,
we're not
I would be cautious about it.
Okay.
I would even like to color code, to your point earlier, enforcements that affect people personally, physically, versus enforcements that are administrative.
Sure.
And even and even vocations that are more imperative towards somebody's health versus somebody who's not so vested in it. But I would tell you that I think that it's important that after the testimony that we heard today, from my opinion, that we be very cautious
Move
about
slow
that,
and
and I
deliberate.
think we probably wouldn't pause that one until
Will do.
we can get our hands around it. Because again, I commend the speed by which it's impressive. I've been a part of many boards, but sometimes we run over some things when we go that fast. And so just, if we can put the brakes on that a little bit, I'd appreciate it.
We will.
And I'd let the father know that he was impactful for that. I think I have kids, and I think he would be appreciative that he's moving the needle.
We, probably about 5 or 6 of the staff members met with him in the room, as well as with the governor's liaison, and had a good 30-minute conversation. And the theme that came out of the meeting is he felt heard. He said he felt heard here at this body,
Good.
and I think that means a lot. And that's not just the staff doing today. We've had interaction with him already and had the same level of contact, and we'll continue to do that.
Mr. Shaw.
Brian, you've probably heard of the statement, the Abilene paradox, and that usually happens, it's like the road to Abilene. This is probably one of those documents that could end up being that whole Abilene paradox if we're not very careful. It's a great document, you've written it, we've read it, we are going to approve it tonight, but I really seriously urge that this commission requests the director to bring back maybe at a biannual basis, a review of the document to see where we're at, what we're
Scorecard.
doing. I think that
That's a
would
good
be
point.
very important for us so that this doesn't get shelved. And, I mean, like any other good plan, from urban planning to business planning, plans like this are well-written, well-read, and well-approved, and then they get shelved. So if it's okay with you, Mr. Commissioner, as part of our motion, maybe I'd like to add that this is brought back to us probably on a biannual basis, and without putting undue burden on staff.
It's not going to be an undue burden. In fact, we welcome that. If you look on page 5, one of the things that we've always tried to do historically with our strategic plan is to say, hey, this came out of the previous plan, and we want to tell you what we've done. And so page 5 reflects the strategic initiatives that were established in the previous plan. This plan includes timelines that we have to meet, that we've already made commitments for on the goals. And you will see our dust or our effectiveness in regard to those legislative initiatives. So we welcome that, because we will be reporting back to you our efforts, and you're going to be seeing that movement. So that's absolutely welcomed.
So with that, I'll make a motion to go ahead and approve the strategic plan that's presented to us for 2017 through 2021 for the Texas Department of Licensing and Regulations, with a caveat that staff, in some form, whether it's electronic or verbal, brings back an update on where we're at and whether we need to make any course corrections or anything else on a biannual basis.
We have a motion?
Mr. Commissioner, could we also add allowing the staff to make any non-substantive editorial and formatting changes?
Absolutely, absolutely.
Second.
We have a motion and a second.
So we won't add or subtract any knots.
Yeah, leave the knots in. So, all right, we have a motion and a second. Again, great job by the staff. I appreciate the input that we received throughout the state of Texas. I think what people have to understand is that the town hall meetings that we had out in the state of Texas, this is the result. This is what we have right now before us. So I appreciate all the industries and people that have come out and made comments and were able to provide us with kind of a path in which we could present to the governor's office and the legislature. We now have that document, so we hope that the governor's office will accept it and be able to move forward and know that we continue to be on the forefront of initiative. And as I've heard through Bill and Brian, it's not best practices, it's next to practices. That's what we're after. So we have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries unanimously. So I appreciate it. Real quickly, I think that there needs to be a recognition made.
Yes.
Along that line, I would want to be able to, I know that he's not at work today, but for Gene Mays, who is going to be leaving the agency June the 30th, let him know that he will be missed. Let him know that he has taken our customer service and moved them in a fantastic direction. I think he will be leaving this agency too soon, but he'll be leaving this agency at a time that he needs to. So we do have a new director in place, and for that I'll go and turn it over to our DED, or our DED to be DD or ED. I don't know, I'm tired of that already.
Mr. Chairman, go.
Mr. Chairman, Brian Francis, all those titles.
I agree with you. The customer service division for TLR is exceptional, and that's something that Commissioner Collier loves. She likes the word exceptional versus excellent, and it is exceptional. And it is due in part to the vision and the heart that Gene brought to that organization, but it's also due in part to the team that he put together. His leadership team was Gene Mays, and it was Irma Mendoza and Trey Seals. Those three brought the balance and the effectiveness needed to create a successful group. We were fortunate to have a lot of folks wanting to throw their hat in the ring for that position, and we were very fortunate to snag one of the folks I think is going to do an incredible job for us. So I'd like to introduce the new director of customer service, Trey Seals.
Spray. And Trey, if you want to be able to say anything, I'll give you 3 minutes.
Seriously?
Okay, how about just a minute then, because you're pretty eager about that. Again, if you'd like to say anything, please.
To the table, please. Clock starting now.
I'm just memories from what you said, what Brian has said about the job that, the example that Gene and the mentorship that Gene has been the leader for the last 10 years and working with that. The three of us, Irma, Gene, and Trey, we were the three musketeers, and he is leaving too soon. But I feel well prepared. I'm excited about the opportunity to carry on what we started. And I'm excited to hear your comments on what you'd like to see for the agency and staying on course. So I'm here to work, and we've got a great team. They're excited about all the changes that are coming. They're a little scared, and but we're going to make sure that we're ready. And so that's our commitment to you and to Bill and Brian. And we're so grateful. Thank you for the opportunity.
Congratulations, Trey.
Commissioners, it's important to note that Trey is the second person to take a leadership role as the director in our agency that came from a program that was consolidated into TDLR. So Jerry Daniels was with the Barber Board, and now he's a director in the agency. Trey came from the Cosmetology Commission, and I think it's a statement that TDLR doesn't take you over and discard you. TDLR makes you part of who we are, and you make us better as an organization. So I think it's a great statement to the folks that have joined our team, but those that are going to be coming on board in the future, knowing that there's going to be a place at the leadership table for them.
Well, and I think that also, again, congratulations to you. I know there was a very highly competitive field of applicants, so which made it very difficult, but it's really a good difficult to have.
Yes, it was.
So, I mean, so congratulations to you. And again, Gene, you're probably not listening, but I want you to know I'm going to miss seeing you the way you dress. I used to tell him all the time when I grew up I wanted to dress like him, so he was a great man. So
That's awesome.
Thank you.
Thank you.
I'd like to add one thing also. I pray that you are fortunate enough to find the right employees that will constantly be mined from your department.
Thank you.
That's funny.
Thank you.
All right. Let's move on to item N. I'm just kidding, Christine. You're already walking up here. So let's move on to the criminal conviction guidelines. And we have, I think, 4 of them here. So I think we'll go one by one, but Christina's going to stay up here hitting them all. At your discretion, Ms. Kaiser.
Good morning, Mr. Chairman, Commissioners. I'm Christina Kaiser, Director of the Enforcement Division here at TDLR. You have before you today 4 sets of proposed criminal conviction guidelines. Those are at agenda items J, K, L, and M. They are for athletic trainers, hearing instrument fitters and dispensers, orthotists and prosthetists, and finally speech-language pathologists and audiologists. If it's okay with you, I would like to give some introductory remarks once and have that introduction apply to all 4 sets of guidelines. I will actually present some of the guidelines, and the lawyers who work the criminal background cases, Ken and Bob, will also present some of the guidelines, so we can just break it up a little bit. With me at the other table is Chris Russey, who is the Research and Analytics Specialist for the Enforcement Division. Chris is going to help me with this presentation by having the guidelines up on the board. We can also pull up Chapter 53 or anything else if you need us to pull it up if you have questions about anything. Chris does a lot of the heavy lifting on the criminal conviction guidelines and also on our penalty matrices. So this product would not be before you so well put together were it not for him. By way of background, the criminal conviction guidelines are used by the agency in making determinations about whether an applicant for a license should have the license denied due to their criminal history. The criminal conviction guidelines are actually used in a couple of places in the organization. Any individual who applies for a license is subject, or applies to renew a license, is subject to a criminal background check. Those criminal background checks are requested by our licensing division. And when the results come back, the licensing division is the first division that uses the criminal conviction guidelines. They review the criminal histories that they receive back from DPS, and they compare those against the criminal conviction guidelines. And if there is no crime that appears to fall within the categories, then licensing will clear the applicant and he can move on through the licensing process. If the licensing division finds crimes that are a cause for concern, in other words, crimes that do fall within one of the categories that are in the guidelines, then they will refer that application over to my division, enforcement. And we will then make a second preliminary screen of the criminal history with reference to the guidelines and make a determination. We may also clear the license applicant at that moment and let him get on with the licensing process. If we think we might want to deny the application, however, we will open a case for investigation. The prosecutor will give the investigator specific instructions about the type of information he wants him to gather about the person's criminal background. And then at the conclusion of the investigation, the prosecutor will make the decision. As you know, those of you who have been on this commission for a time, full due process is available to people after we seek to deny their license. It's not simply oh, well, enforcement says no, and boom, you're out of here. If enforcement says no in the form of a denial letter, then there is an opportunity for a hearing and then a final decision by this commission, and then further judicial review is appeal is available after that. Chapter 53 of the Occupations Code is the general authority that we rely on most often to deny people's licenses based on their criminal history. Specifically, Section 53.021A of that law says that the agency may suspend or revoke or deny a license to a person who has been convicted of one of 4 categories of crimes that are described there. Before I get into those 4 categories, I want to point out the word may, because that's hugely significant. One of the foundations of our criminal history review process at TDLR is that it's very much a case-by-case basis. It is very seldom that you see an automatic, if you have this conviction, you're automatically denied a license. There are a few of those type provisions that exist in the individual statutes for some of the industries, like the licensed breeder statute has one, for example. But as a general rule, the criminal background review is very much case by case. So as I said, 53.021A, the agency may suspend, revoke, or deny to a person who has been convicted of. The first category is the most important: crimes that directly relate to the duties and responsibilities of the licensed occupation. Directly relates, that's the whole point of why we're here today. The criminal conviction guidelines are our attempt to say to the world, these are the crimes that we believe directly relate to the duties and occupations of these various industries. The other categories include things that the legislature thought were important enough or significant enough types of crimes that we could deny based on these, even if we don't make a showing that they directly relate to the occupation. In most cases, we believe that these crimes do, however, relate because they're fairly serious. The second of the 4 categories is crimes that were committed less than 5 years before the date of the application. The third is crimes listed in Section 3G, Article 4212 of the Code of Criminal Procedure. These are the worst of the worst types of crimes: murder, capital murder, indecency with a child, aggravated sexual assault, etc. And the 4th category under that listing are sexually violent offenses as defined in the Code of Criminal Procedure. And many of these are the same as in that previous category. There are things like indecency with a child, sexual assault, aggravated sexual assault, aggravated kidnapping committed with intent to violate the victim sexually, burglary with intent to commit a felony sex crime, and other things of that nature. As I told you a moment ago, the directly relates language is the most important. That's also the language that we rely on the most often in our criminal background types of cases. We do plead these other categories independently, but we found through trial and error that if a crime falls in one of those big categories that I just described, it's also going to be something that we believe directly relates. So the directly relates is often, almost always going to be the analysis that you hear when these cases come before you. So as I said, the criminal conviction guidelines are our effort to state to the world the categories of crimes that we believe are directly related to the occupation. There's another reason, a more practical reason why we need to adopt the criminal conviction guidelines. There's a provision in Chapter 53 that says we have to. 53.025A requires the agency to issue guidelines. The first set of guidelines that are in front of you are the proposed guidelines for athletic trainers. These guidelines were developed by the enforcement work group of the advisory board, and those folks worked in consultation with the agency staff. The work groups helped us to understand the settings in which these professionals work, and the types of clients they serve, and the nature of their contact with those clients. We also, with each work group, had some very heavy discussions about what kinds of crimes should be a possible basis to deny someone a license in this particular industry. For the athletic trainers, the enforcement work group met with the staff on March 16th, and then we exchanged emails afterward to finalize the document. The work group members are Daryl Gaines and Dr. David Schmidt. Those are two members from the Athletic Trainers Advisory Board. So after the work group was finished finalizing the draft document, we then presented it to the full advisory board. The Advisory Board of Athletic Trainers met on May 23rd, and after we presented them with the guidelines, they voted and recommended approval by this commission. And I will be asking today that you vote to approve the guidelines. If I may, I'll just take a few minutes and sort of walk you through what's included in the guidelines. Please ask questions if I'm going too fast on anything or if I'm unclear. When you look at the guidelines, you'll see that the crimes are described in terms of categories. We don't attempt to list exhaustively every possible crime because from one jurisdiction to another, very different words can be used to describe the same crime in an order of the court. So that would be a fool's errand to try to do that. So we've used the categories, and this has been a very successful methodology for presenting the guidelines. The categories, under each one, you'll see that reasons are listed. These are our attempt to state the reasons why we believe this category of crimes is directly related to this occupation. As you walk through the reasons, you'll see a couple of themes that are repeated fairly often. For example, under crimes against the person, such as homicide, kidnapping, and assault, you'll see the first reason is licensees physically interact with adults and children in an athletic trainer-client role. Individuals who have committed crimes of this nature would pose a potential danger to the client. That concept of potential danger to the client is pretty much repeated on every one of these because we think that's kind of a base level consideration that we should not lose sight of. Similarly, the third reason listed there, the occupation involves close proximity and physical contact, and sometimes in a private setting, and therefore provides an opportunity to engage in further similar conduct. That's another concept that you'll see repeated through most of the categories in most of the guidelines, the opportunity to engage in further similar conduct. That's actually one of the many factors in Chapter 53 that we are required to take into consideration. So the categories include crimes against the person, such as homicide, kidnapping, and assault, because the reasons being those that we just spoke of. The next two categories, crimes involving prohibited sexual conduct and crimes involving children as victims, include some other reasons that the majority of athletic trainers have contact with minors. They operate in a relationship of trust with their clients. It's often, the business is often transacted in a private setting. The interaction between a trainer and a client sometimes lasts for an extended period of time, and bonds of friendship sometimes develop. Those are all additional reasons why we believe those crimes, crimes of a sexual nature and crimes with children as victims, are directly related to this occupation. On the next page, you have crimes against property, such as theft or burglary. Licensees do have access to the property of their clients, and again, there's that relationship of trust which creates the opportunity for that type of crime. Crimes involving fraud or deceptive trade practices. This was discussed pretty heavily at the work group level, and you'll see that we have some specific reasons there as well for why we believe these types of crimes are related. Licensees, athletic trainers, are sometimes involved in the billing of clients and others, such as school districts or hospitals. They're also sometimes involved in filing insurance claims. They also are in a position to advertise and make representations about products, about services, about insurance benefits. So all of those are unique opportunities within this profession to engage in fraud type behavior. On the last page, you'll see two categories of crimes that have to do with drugs. And these also were widely discussed at in several of the work groups, not just the athletic trainers. But we generally, after a lot of discussion, we decided that there were actually two different categories of crimes that had to do with drugs or illegal substances. One is the category that we will loosely call the drug dealer category. And that's the first one here, crimes involving possession with intent to deliver, delivery, distribution, et cetera, of or manufacture of drugs. The second is the category of crimes involved being under the influence of drugs. So you see the difference. For the first category, the one I've loosely styled the drug dealer category, the reasons listed there are very similar to the ones we discussed earlier. The contact with minors as clients, the relationship of trust, the extended length of the relationship in some circumstances, and also the fact that clients often will be under some type of pain medication. And so they are potentially vulnerable to someone who might want to sell them drugs or might want to influence that person to secure drugs for them to sell elsewhere. The category of being under the influence of alcohol or drugs, our primary thinking here was that if someone has alcohol or drugs in his system while acting as an athletic trainer, he could bring harm because of the physical contact and the nature of the work. As I mentioned, the advisory board did vote to recommend that you approve these guidelines. I am happy to answer any questions, and I would ask that you vote at this time.
Any questions?
I have a quick question. On the drugs that you're talking about, are they specifically to, I'm not sure how to word this, but are they specific to training, like steroids, stuff like that? Or are they just in general? I mean, because there's no definition of what a drug is.
Which category are you asking the question about?
Let's say all of them.
We did not narrow the category to define certain types of drugs. We felt like the type of behavior was a potential harm to the clients of athletic trainers, whether it was drugs that would typically be used by an athlete or not.
Is there a difference between the type of drugs they might have been charged with a crime, like as opposed to a small amount of marijuana? Would that be considered a reason why they shouldn't get a license in the future because you're afraid that they might deal with like illegal drugs such as steroids or other enhancing drugs? Is there a distinction between?
There's always a distinction. If you'll remember from earlier in the discussion, every case that we look at is going to be a case-by-case analysis. And we're going to be looking for individuals who present a danger of committing these crimes upon their clients. Someone with a single conviction for a small amount of marijuana, I doubt that they would even get past the initial screening by the lawyer if that's all they had on their criminal background. So I'm not worried about these categories causing us to deny licenses to someone like that.
Well, I guess I'm a little confused because historically in cases, we have used that if they've been charged with possession. It's always been one, like if they've had it, it's always been listed as a reason
Right,
why.
it's part of their criminal history, it will be listed, but if that's the only thing a person has, you're not going to see a denial action just based on that, if that's all they have.
I guess what I was trying to figure out is, was the type of drug as well as were they dealing in drugs prior to this, or is it personal use also considered something that should prevent them from getting a license?
The second category is crimes involving being under the influence of alcohol or drugs. So their personal use is a consideration. But again, the magnitude of the crimes and how recent the crimes are will be big factors that we look at in determining whether to deny someone a license on that basis.
And I think that what I'm looking at here is when you separate the possession with intent to deliver, to distribute, delivery, distribution, manufacture of drugs, that in itself, a conviction of that shows a propensity to basically be a drug dealer. Which
Right.
means that you're willing to try and pass it out.
Right.
But as you're talking about kind of the casual, which falls under the being under the influence, I think is for personal. There's a distinct separation between the two.
Right.
So, I think that's why, and I'm glad that that's why we've done it, is because I find much more egregious to be under the possession with the intent to delivery, substance. That's much more egregious. And by no means am I sitting here condoning drug use, but I find it much more egregious crime than the simple influence of. So.
Right.
No, I agree,
Yeah.
just trying to get a clarification.
And this would be effective when? Criminal conviction is be.
The
immediately?
criminal, there's not really an effective date. These are not rules.
they would
It would
just
be
be-
published as a policy of the agency.
Okay.
And then they would be in place and ready when we start actually receiving applications for this industry.
Okay, so, Mr. Shaw.
I really want to try to support this today and get this thing going, but I'm still asking the question about how, from a legal standpoint, how do we come back in? And I'm kind of having some foresight here. If we hear a case, let's just hypothetically say if we had a case in front of us, and how am I to determine what drug was really a level 1, level 2, level 3 drug? I mean, is it Advil? Is it pre-workout drugs, post-workout drugs, or is it, drugs like marijuana and cocaine? I mean, I'm struggling with that a little bit, so help me to understand, how are we going to be able to measure that?
What you're not going to be asked to judge a criminal case. The criminal case will have already been done at that point, and all we will have is what we know about the conviction and about the circumstances behind the conviction. So what you will see is a case in front of you where this person has one or multiple convictions for some type of possession with intent to deliver or actual delivery or manufacture of drugs. And then if these criminal conviction guidelines are adopted for the reasons, stated here, then our argument will be to you, based on these convictions plus all the other circumstances of this person's current situation, we believe this person presents a danger, and that putting them in the occupation will give them the opportunity to further engage in this type of criminal behavior.
I think I'm with you now. So you will make that measure based on whether somebody got a DWI versus a full conviction on manufacturing cocaine.
Right.
I'm with you.
Right.
I'm with you. Thank you. I think I understand what you're saying. I apologize.
Oh, no, I ran through it very fast. And
I had one of those crayon moments where I was a little short on the colors.
I'm a little confused. Christina, earlier, I thought you said if there was only if it was a possession of a drug or something, it would go into a collective, a larger number of possible past crimes or history that would prevent the person from getting a license, like why the attorney would have made the decision to pursue. Do you understand what I'm saying?
I'm not sure I do.
Okay, a few moments ago, when I was asking you about, is it possession of marijuana, would that stop someone from getting a license? Or is it something related to it, like delivery of another substance of some sort? And you said, well, it's under 2 different categories? And if there was,
And I think you had mentioned personal use.
right, personal use, that it would be the attorney would have already addressed it, determined whether it was worth seeking the enforcement
Right.
against it. How do the attorneys know, are there guidelines that you are providing them so they have a basis to evaluate whether they pursue a revocation or not?
The guidelines that we're seeking your adoption of today are something that they apply. There are also a multitude of factors that we take into consideration that are listed in Chapter 53 of the Occupations Code. Those include the nature and extent of the person's entire criminal history, the period of time since their last conviction, their age when they committed multiple crimes, the
Right, I
various
agree, and that's what I
crimes.
was trying to
So
think
it's all of those factors are taken into consideration. If we see a crime that's within a conviction, that's within one of these categories, that's just a flag to cause us to take another look at that person. That's definitely not the end of the analysis. So we look at what is the extent of the person's criminal history, plus all those other factors, and it is very much a judgment call by these lawyers on a case-by-case basis about whether we pursue a denial or revocation on each individual applicant.
Exactly, and that's what I was curious. I've just always wondered how it works. Like, is there some type of guidelines for the attorneys to know which to pursue and which not to pursue?
It's those things I mentioned. These
Right,
guidelines.
those are vague. I'm just wondering, like, do you have like a guideline standard?
No, not beyond these and Chapter 53 of the Occupations Code. Plus our history of, presenting cases to this commission and having feedback from this commission about the types of crimes that, they're concerned about and the types of crimes that they're not.
Okay.
Any other questions? Motion would be in order to accept the guidelines for the athletic trainers program.
So moved.
A motion, second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's move on to the hearing instrument fitters and dispensers.
That will be Mr. Ken Sharp.
Mr. Ken Sharp. I thought you were going to grace us with your presence on all of them. Mr. Sharp.
AKA Karnak.
No, that's Bob.
Oh, Bob, I'm sorry.
The strange thing is, he knew you were going to say that today. Well, good morning, Commissioners, Mr. Chairman. My name is Ken Sharp. I'm an enforcement prosecutor with the Enforcement Division here at the Department, and I'm here to present to you the criminal conviction guidelines, or the proposed criminal conviction guidelines for the hearing instrument fitters and dispensers. On April 15th, the work group comprised of some members of the advisory board for that occupation, and also some members of the staff met, and they developed the these proposed criminal conviction guidelines. And then on May the 24th, the hearing instrument fitters and dispensers advisory board met. They voted and they recommended that you adopt these criminal conviction guidelines. And of course, we would ask you to vote on those when we get finished. If you don't mind, I'm going to just refer to these as fitters and dispensers, because even though I'm a long-winded lawyer, that's even too long for me. So if it's okay.
HIFD, how's that?
Well, something, yeah, an acronym, anything.
And if this is redundant, I mean, it seems like they're pretty redundant. Is that accurate on some of these things as far as?
Some of them are, but I'm going to
Right.
whisk through those pretty
Okay.
quickly. I'm going to try not to bore you or say things over that have already been said.
Okay.
All right, well, if we can get right to it. The first one, as you look at the list there, that's for crimes against the person such as homicide, kidnapping, and assault. And as Christina pointed out, and I said I wasn't going to be repetitive, but I'll just do this. As she pointed out,
Too late.
these people, they work closely. They work in close physical proximity and even have physical contact with their clients or patients. I think clients is the appropriate term. And the fitters and dispensers, they don't want their people in their occupation to pose any type of potential danger to themselves, or to their clients or to the other people they work with. And so that's the reason for this one, their inclusion of this one. Now, they also recommend the next guideline category because the fitters and dispensers work closely with their clients, and that's the one that involves prohibited sexual conduct. Anybody who's committed prohibited sexual conduct is more likely to pose a danger in that regard to a client than someone else. And this occupation would give that person the opportunity to engage in that type of behavior or that type of offense against their client once again. It's a very unfortunate reality that we as a society have to take measures to protect our most vulnerable citizens, those being the children, elderly, and disabled. And we have to take those measures to protect them from people who would victimize them. We don't want that. It's not uncommon for people in that group to need the services of fitters and dispensers. And of course, as I said, that requires them to be in close proximity, close physical contact at times. And the fitters and dispensers do not want people in their occupation who would victimize those among us who are the most vulnerable, and again, especially the children, the elderly, and the disabled. So that's the reason for this particular or this next category, the crimes involving children and elderly and disabled as victims. And just as the fitters and dispensers have a close physical proximity, physical contact with their clients, they also have access to their personal property, to their personal belongings, and not only of the clients, but the caregivers, their friends and family, and even the people the fitters and dispensers work with, the people in their office, the people in their labs and so forth. Additionally, they have a role in billing clients, insurance companies, even helping clients to fill out forms to make claims to the government for financial benefits. And so the next recommendation here is for those crimes that are against property, such as theft or burglary. They want people who are honest in their occupation, and they don't want people who commit these type of crimes. And also, since the fitters and dispensers would likely have a role in billing clients and billing insurance companies, filing government claims, and so forth, the next one is important. It's the category of crimes that involve fraud or deceptive trade practices. This one and the previous one that we just talked about, the crimes against property, they set the standard for honesty for the licensees in this program. The next category includes crimes that involve the possession, distribution, manufacture of possession or of drugs or drug paraphernalia. Now, those fitters and dispensers, they are responsible professionals. They are very committed to providing competent and safe care to their clients, and they're committed to the well-being of their clients and working with people as they do in this type of occupation. This would give licensees a ready access to a new potential customer base if they were inclined to be involved in distribution of drugs. And in some circumstances, a fitter or dispenser would have access to drugs as well, whereas they ordinarily wouldn't have but for the occupation. So it's important in that regard as well. To avoid those possibilities, the board recommends that you adopt this guideline also. And then finally, kind of going hand in hand with that, is the guideline with regard to crimes involving being under the influence of drugs or alcohol. They don't want somebody who's under the influence of drugs or alcohol to be performing those fitness or fitter and dispenser services. This is a technical occupation. It requires a lot of knowledge, a lot of training, a lot of skill. And it not only requires that, but it also requires focus and concentration on what they're doing to make sure they're doing the right thing for their clients. That is totally inconsistent with someone who is under the influence of alcohol or drugs, in some way impaired. And so they want to adopt this one as well. Well, those are the proposed criminal conviction guidelines for fitters and dispensers. And the advisory board recommends that you adopt them, and we would ask that you vote on them. But before you do that, if you have any questions, I'll be glad to try to answer them.
Any questions for Mr. Sharp? A motion to be in order to accept?
So moved. Second.
A motion is second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you, Mr. Sharp.
Thank you.
Again?
Christina again.
Again.
Let's go to item L, which is the criminal conviction guidelines for orthotics and prosthetics. Is that right? Prosthesis.
Prosthetists.
Prosthetist.
Yes.
Prosthetics.
There you go.
O and P.
Right. These, the proposed criminal conviction guidelines for orthotists and prosthetists are before you at agenda item L. These include many of the same concepts that we've already discussed.
Can we go through them all over again, please?
The concept of posing a danger to patients and clients, as well as others, is throughout. The concept of that the occupation would provide persons with these types of criminal history the opportunity to engage in further similar conduct is throughout. The categories include many of those that you've already heard: crimes against the person, crimes involving prohibited sexual conduct. There we also rely on the reasons of the close physical proximity and physical contact with the clients, as well as their family and friends and caregivers in residences and also in private offices. Crimes against the children, the elderly, or the disabled as victims are also relevant to this profession. These are the types of people in all of those categories are included in the types of clients served by orthotists and prosthetists. And because of the close physical proximity, a person with this type of criminal history would have an opportunity to engage in it further. Crimes against property such as theft or burglary are important because again, the close physical proximity, the private nature of the settings in which these folks interact with their clients, the access to property that is there when they're in someone's home or in a private setting. Crimes involving fraud or deceptive trade practices. Here as well, we have included some reasons that include the access to property of others. Orthotists and prosthetists are potentially involved in the billing of clients, the filing of insurance claims, and the filing of documents for government benefits. So those create opportunities for fraud. And then finally, we have the same two categories relating to drugs, the possession with intent to deliver or distribute, or actually delivery or distribution of drugs. Here as well, we mention the patients who are sometimes on pain medications or other medications who are potentially vulnerable to someone who may wish to sell drugs or enlist their aid in obtaining drugs for them to sell to someone else. And the crimes involving being under the influence of alcohol or drugs. We talked about this one for a long time with this work group, and the work group helped us to understand that these licensees use dangerous instruments in the course of their business, things like knives and scalpels and other things that have blades. And so this group felt it was especially important to not have folks in the industry who have a history of being under the influence of alcohol or drugs because of the potential danger to clients. We met with this work group, this enforcement work group from the advisory board on March 14th, and we exchanged emails afterward to finalize the document. The work group members from the advisory board are Kevin Matthews, Catherine Mize, and Randy Duncan. The full advisory board, the Orthotists and Prosthetists Advisory Board, say that 3 times real fast, met on May 19th and voted to recommend that you approve these guidelines.
Questions for Ms. Kaiser? Motion to be in order?
So moved.
We have a motion? Looking for a second?
Second.
Second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you.
Thank you, Christina. Let's move on to item N, which is the speech language pathologist and audiologist. Robert, AKA Carnac the Magnificent.
You stole my line, Commissioner. I was going to say
I could
that
tell you
exact
were
thing.
about to do it, so
I
was
know,
gonna-
I had it written all over my face, didn't I?
I was gonna put water on that flame. Go right ahead, Rick.
Let me say that every one of these occupations we've just been discussing are very similar. It's true that there is a lot of redundancy in these criminal conviction guidelines because they're so similar. Every one of them is a medical related. Their clients are either children or disabled or elderly or someone or a regular adult or someone who has been, but they all have had some sort of medical problem or medical, or except for trainers, of course, but all these others have some sort of medical issue in some related way. And so the guidelines are identical. So, and I don't think the commission has any problem with the crimes against person, crimes involving prohibited sexual conduct, crimes against children, crimes against property. You work in schools, you work in residences, you work with children. It's obvious that you would have access to their client if you are a thief, and you'd want to be able to go after that sort of person to deny their license or to revoke it if they engage in that kind of activity. And I'm assuming the commission has no issue with that. The crimes involving fraud, I think I'm the only one who was at all of these work groups. This came up mostly with regard to Medicaid and Medicare fraud. That's the main reason we wanted to include this, but then there's also the insurance billing issue. So that's a primary reason we included that. But of course, someone who forges checks or engages in credit card abuse, you don't want them in this industry either. Finally, with the drug possession thing, the way this came up, and where it says, in this case, the drug dealing provision, crimes involving the possession with intent, and so on. The reason we listed that in every way that it can occur is because in the federal system, they call it, it's distribution. They use that term in all of their drug cases. In the state of Texas, it's always couched in the phrase delivery. So the reason we mentioned both is one, make sure we didn't accidentally exclude a crime that we would want to address in this setting. So we listed everything, manufacture, distribution, delivery, just to cover that 1 in 100 case. So in all these work groups, we asked the people who were representing the industry, do you want someone who deals drugs in this industry? And every one of them said, no, we don't. Now, whether that person is someone who committed a delivery of marijuana when he was in high school 10 years ago, none of them want that person to be excluded if 10 years later they have the qualifications to engage in this. Well, this is no different than the tow industry, where we have the same thing with drug possession and drug dealing. It's a case-by-case basis. They just don't want anyone who currently is a reasonable risk to be wanting to deal drugs in the industry, and that's the same way we would intend to apply these guidelines. So that's how that came up, mostly because their patients can be children, they can be students in schools, they can be people who have medical problems and may be on medication themselves and therefore vulnerable to someone who wants to deal drugs, and that's the reason that provision was put in there. The last one, where someone under the influence of drugs or alcohol, that came up mostly because I asked the commission, what if you have someone, or the work group, what if you have someone who's had 5 public intoxication convictions in the last year? Do you want that person to have this type of license? And they said no. Every one of the work groups said no. This isn't just to get someone who has a personal amount of even cocaine or marijuana, less than a gram of cocaine, they're driving along, they get stopped for speeding, and the cocaine is discovered. That's not the reason we've put this in here. It's because someone who's showing a current addiction to drugs or alcohol. That's the reason this is here. And when we have that 1 in 100 case where someone has like a string of convictions for alcohol or drug possession or intoxication in the recent past, we might want to deny it. It's going to be a very rare situation where you'll see a case where this is the reason for denying the license. So other than that, we met in March with the work group, April with the full advisory board. They recommended these, and I ask that you pass them.
Any questions for Mr. Rennick? A motion would be in order.
Make a motion.
So moved. I'm sorry. We have a motion.
Second.
Second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, sir.
Thank
Appreciate
Bob.
the Enforcement Division for the work that you've done in this. I know that it was a tedious process, but a necessary process. Thanks for all your work. Move on to N, which is the Comptroller's Methods of Assistance Program, the MAPS. Who's going to be doing that?
It's going to be Russ Tolley.
Hey, Russ. Go right ahead.
Hello, Commissioners. My name is Russell Tolley. I'm a program specialist in the Compliance Division. I'm providing today the final report on our review of the Comptroller's Methods and Assistance Program, or MAPS. These were audits from 2013. The tax code requires the Comptroller to review the tax appraisal districts every 2 years. This review is conducted by the Property Tax Division, and it's called the Methods and Assistance Program. This MAP audit is an assessment of how well the appraisal district performs its duties regarding governance, taxpayer assistance, operating procedures, appraisal standards and procedures and methodologies. It also includes recommendations from the comptroller to the CAD on how the CAD can improve its operations. Under the tax code, the CAD has 1 year to resolve those recommendations at the comptroller's office. If any unresolved issues remain, they are referred to TDLR and they have an additional year to work with the programming staff here to resolve those problems. These particular audits were initially made in 2013. They stayed with the comptroller following year, 2014, to resolve those comments. They were referred to us, any unresolved comments, at the beginning of 2015. They worked with us throughout the year, and this is a summary of those reviews. I'd like to recognize 2 program specialists that work with me, Roger Thormalin and Lisa McDonald. They did the heavy lifting and worked directly with the CADs on resolving the issues. 13 counties were referred to TDLR, and those are listed in the agenda, and they are Bowie, Burleson, Clay, DeWitt, Hopkins, Leon, Medina, Nacogdoches, Ogletree, Reeves, Throckmorton, Uvalde, and Winkler. Page 2 of the report that I gave you has a chart that lists each of the counties' progress. For example, Bowie on the first line had 15 recommendations from the comptroller in its initial map. One of those recommendations was unresolved and was referred to us. They resolved it, and we were required by tax code to deem them substantially compliant with the map or not.
What is the deal with Uvalde County? I'm sure you're probably getting to that, so let me jump to it.
I'm getting right to hear that. Uvalde had 7 recommendations in the map. 7 were referred to us. They did not resolve any of those issues with us. Basically, it was a lack of a response from Uvalde for our request for information, their inability to work with us.
Have they still not responded back?
They did respond to us on the very last day of the year. Just note that this is the second map review from Uvalde, and this was the second time they delayed throughout the year and responded at the deadline or after the deadline for the comments.
So what ramifications does TDLR have with this particular, when they fail to reply or fail to?
Well, we're required to report
resolve?
back to the CAD whether or not they've complied with all the recommendations or not recommendations. There are, in our regulations, there are provisions that require them to respond to us and to meet the maps. So TDLR could refer this over to our enforcement division for enforcement action if we wanted to. I would like to note that the the appraiser that we work with from the county is no longer with the county, which isn't unusual. When prior CADs who were unresponsive, usually the board of directors in the county will find another appraiser. That's happened here. Uvalde's currently working on with an interim appraiser, and they're undergoing a search for a new appraiser, chief appraiser.
Okay, because that was going to be my next question. Does the CAD board receive this information?
Absolutely. As we noted, Uvalde is the only one who did not resolve the comptroller's recommendations. To you, I'd come today, and the next process is to issue a letter to the board of directors of the CADs and let them know either one that they have met the recommendations, which would be all the counties with the exception of Uvalde, and then a letter to Uvalde letting them know that they have not fulfilled the requirements.
They were there last year.
All right. And that's my report. Ready for any questions?
Any questions for us? You need action on this, or is it just simply a report?
Just my report.
Okay. That's what we need. Appreciate it. Thank you,
Thank
sir.
you.
Let's move on to the staff reports. I guess our ED and DED, soon to be DED.
Call your attention to the agreed orders. We had one agreed order on breeders in this packet. This last week, I've signed several other agreed orders with the breeders with the inspections that we've been doing, so there is some activity in that particular program. That program is unique in that the penalty fees go into a fund that is used to pay for education or the operation of that fund, and that helps with the defray the expenses of that small program. That fund was set up much like the Operation Game Thief. We did not get the traction in there that the Parks and Wildlife got for the Game Thief program, but it is something that is an alternate means of providing some education and paying for the transportation of the inspectors out to the sites to inspect.
Question on that. Don't I remember that part of the reason why was because we discovered that most of the dog breeder issues has been more the middle person in Texas as opposed to the breeders? And that's why possibly we thought the license had been not quite as big as we had expected? Have we made any more, I'm guessing that's an affirmative, Brian, just for the record, I mean, just because we're on boards.
Yeah,
Yeah.
absolutely. I was just going to let you finish your
Okay.
thought. The
Well,
definition of a licensed dog or cat breeder does not scoop in everyone who's engaged
Yeah.
in selling dogs and cats. And in fact, the way the three-part threshold's written is you can have someone who sells 200 dogs but only has 10 intact females.
Right.
They would not be required. And that's what we discovered is that it's so narrowly crafted, the statutory definition, that the number of breeders is just going to be low.
Have we considered, I think you did in the past, but have we considered anything for the future legislative process if we're going to try to encompass all those people that have kind of slipped out the loophole?
There have been discussions, not from our end. It is a very contentious and very passionate issue, as you can imagine. And I think some folks who would want to tighten up that definition have concerns that if they even open up statute, the whole thing could go away. Other people think that if you open up statute, it could get bigger. And Commissioner Yerko, they are, both groups are very, very engaged in the process. For us to take a position on that would not be advisable. But if there's a bill that's introduced, we always engage in terms of making sure it's written in a way that if it comes to us, we can implement it. But in the last two sessions, there was some discussion about maybe moving it to the ag department. That kind of fell by the wayside. But there's been no discussions in terms of a bill being introduced or even language being floated around that would change that definition that we've seen.
I thought the numbers of the license kind of made it somewhat of a burden because it really couldn't carry itself.
That is correct. It does not have a very large critical mass.
Right.
And that's one of the things that we have to raise enough funds to cover the expenses for that. So that's always a balancing act that we have.
Right.
And that's why that provision where any penalties from that go into that. And the other thing that would be wonderful is if we had donations like the Texan Parks and Wildlife program does. The only two donations we got were from the computer program director who put in a $100 donation just to test to see whether the system worked. And then Chairman Frank Denton put a donation of $100 in just to see if it worked also. That was the end of the donations. So it'd be nice to see some donations come in so we could do more things.
Do we advertise it out of curiosity?
We've not done any advertising of that recently.
Because I got to be honest, I don't think I even knew that.
In recent months, it's been advertised for us. The Texas Humane Legislative Network has taken upon themselves to bring it to their members' attention.
Oh, that's
And so
okay, that's what I was wondering, yeah.
When you go to their page, they have definitely given it a higher priority or presence than what we had before. The other thing I'll just say that the donations haven't come to the traditional process, but in terms of penalties, those have been added to the fund.
And then on presentations and outreach, the one that's not listed there is the conference that Chairman Aris Mendez and I attended last week at Harvard. That conference was extremely good. It was the Public Sector for the Future Summit, designing the public services for a digital world was the topic of the conference. We had discussions about millennials, which I think is going to be very beneficial to us. We talked about that. The interesting discussion was from Sloan Gibson, who is the deputy for Veterans Affairs for the Veterans Administration. And the thing that, whenever I hear about the Veterans Administration, the only thing I hear about is that the people couldn't get an appointment and that the system's broken and something needs to be done. But when he went through explaining exactly all of the things that they've done, it's been phenomenal. Pointed out that their system, they have some glitches, and every one of those glitches gets publicized. But the successes don't, and it's one of the things that I think that we've been very fortunate with TDLR. We've been able to advertise our successes, to brand our agency, and have that positive feel for TDLR. And the Veterans Commission does not have that. They talked about the paperwork and how they had all of these paper documents that they were trying to keep up with the veterans' records, and they had to reinforce the floors of the building warehouse that all the papers were in because the weight of them, because they had the file cabinets, and on top of that they had papers stacked all the way up to the ceiling. They had a picture of the warehouse now. It was completely empty. You just saw this long shot. All of their records are digitized now. They made the point that they've done a lot of research and they've been on the forefront of medical research. And they've also pointed out that 70% of the doctors today have had some type of contact with the veterans hospitals, either research or interns or residencies, that they really provide a lot of medical services and training, and none of that ever gets discussed when it happens. And it's that the unfortunate thing is that soundbite of I couldn't get my appointment, or my appointment I had to go too far away to be able to get it. Or with the new system that if you couldn't get the appointment, you could go to your own doctor that they would fund it, and they didn't bring that up fast enough. I felt very fortunate about TDLR and the way that we've been able to stay out in front of the bad news so that if there is bad news, people hear it. But that's not what they remember about TDLR. They remember the good things. And then we had a discussion by Sandy Petland, Big Data, and I thought that people at Harvard were smart. Sandy's from MIT, and he was so smart I was having trouble keeping up with him.
My eyes glazed over.
Yeah, he had a Einstein head of hair, and it was coiffed about the same, just all over the place. But the things that he was able to talk about with big data was really interesting. And it's something that we'll be looking at in the future. And you can see little bits and pieces of it that are happening today that we're going to be facing that in the future. And then one of the things that was on the radio this morning coming in, and that the chain, Mike, help me on the term, blockchain.
Blockchain.
I think that there's some breakdown in blockchain for a Bitcoin type thing.
Right.
And from what they were talking about, that shouldn't have been happening. So it's going to be interesting to see how that shakes out. So, and on personnel, we've got Dee Mater here to tell you a little bit about something that they're doing in the IT area and recognition that some of our personnel have received.
Come on up.
Good afternoon, Commissioners. I'm Dee Mater, and I'm the IT Director, and it's my pleasure to be here to talk to you all with Bill and Brian's encouragement and support to primarily recognize the outstanding work that one of our IT staff has done. When I first came here in November of 14, we did not have any kind of IT governance process or project management process or portfolio management process of any kind. And fortunately, they had the foresight to give me a project manager position, which I filled about 3 or 4 months after I started. And I got an outstanding candidate in the person of Mr. Kenny Wright. And he has been working within the organization to build those processes and governance into the work that we do ever since he's been here. And I think he's won over the hearts and minds of everybody and got everybody convinced that we do need project management. We need some standard processes to abide by, and that we're going to get our work done better and faster with those. So toward that end, I was asked to nominate, if I wanted to nominate someone for an Outstanding IT Services and Support Award for the Center of Digital Government conference that took place yesterday. And I nominated Kenny a couple of months ago, and he was accepted, and he received his award yesterday. So he's got a nice trophy on his desk now as recognition of the service. So I think everybody here that's worked with Kenny would support his getting this award and the work that he's done for us. So thank you, Kenny.
Congratulations. That's great.
It's his birthday today, by the way,
that's
so he
great.
took the day off, so he's not here to see this.
Trophy and a day off.
Trophy and a day off. Y'all have my IT status report, and that pretty much is telling you what's going on. If you have any questions, I'm here.
Thank you.
Thank y'all very much.
Doing a good job. Thank you so much.
Thank you.
The ship is without a rudder.
Well, then I say we call the meeting. No.
Well, while we're waiting for the chairman to come back, he has a report that I think that each of you have.
Yeah.
So that you could take a quick look at that on, because that's the next item on the agenda, I think.
That's correct.
Mr. Chairman, we're up to your memo about the advisory boards.
Just real quickly, what I want to do is go back to, Commissioners, back to item N, the maps. I've been advised that we probably do need to go ahead and take action and approve the report as presented to us in order to be able to notify the counties that it has come before this body. And in case there's any further action needs to be taken with those, with the appraiser or the CAD, it can be done if the commissioners approved it. So at this point in time, if you don't mind, I'd like to go back to N and accept a motion, or to receive a motion to accept the report as presented to us by Russ.
So moved.
Second.
A motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, Brad. Commissioners, item P, which is the advisory board you have before you. One of the things that we have, that I have attempted to do, and I want to thank Mary and Tamala and Delia for helping me get this to where we actually, I think we're starting to function now. About 2 to 3 weeks ago, you received a memorandum stating all of the individuals that we were looking at placing on advisory boards. You receive their applications, and it's, we do that in a way or for the purpose of allowing you to be able to review those applications prior to, and not just simply get on the day of, which I swore I would never do, and I continue to do. So anyway, you now have before you a memorandum for appointments, and I have been told that I need to read these. The Architectural Barriers Advisory Committee reappointing, I'm actually appointing John Rickard and Michael Olson to the AV Advisory Committee.
approve those two nominees or two appointees.
Yes. I'm sorry, and let me, before I forget, and reappointing Philip Pierce as the presiding officer, Gregory Edwards, and Rob Roy Parnell. My apologies, I forgot to name those three. So,
Motion carried.
we have a motion.
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. To the Combative Sports Advisory, this was the former Medical Advisory Board, which has now been changed due to legislation that we received, to the Combative Sports Advisory. And so this is basically appointments to the advisory board. As presiding officer would be Dr. Wayne Lee. A part of the board now would also be Dr. Manuel Gonzalez, Dr. Randolph Taylor, Dr. Richard Shrem, Mike Battah, Mike Maynard, Carrie Hatley, Chris Reed, and Blaine Sibley.
Move to approve.
We have a motion, second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. For the Dyslexia Therapist and Practitioners Advisory Committee, to appoint Robin Cowser as the presiding officer, Helen Masick, Misty Dempsey, and Atricia Nagos.
So moved.
Second.
We have a motion and a second. I would also note that there is still a position available there, and we're waiting to be able to fill that, so I'll come back to the commissioners later on the point in time for that one. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. For the Elevator Advisory Board, appoint Jerry Mathney, reappoint Nancy Crumley, and Lawrence Taylor, who's actually out in the audience.
Right there.
So,
Yeah.
so you have those before you?
So moved.
Second.
A motion and a second, all in favor signify by saying aye. Those opposed, motion carries. Again, commissioners, just kind of so you'll know, if there is someone that you would like to be able to see or someone that has an interest, please let me know, have them go to the website, fill out an application. If they can't find them, have them either contact Mary, Tamala, or Delia, and they can help them out in trying to get those. There's still some openings that we have. You'll probably get some additional ones later on down the road. Along that same line, as far as appointments, in our next meeting, we will have a agenda item for a vice chair. So you may begin to start thinking about that, who you would like to be able to replace me with, in the event that,
Replace you.
well, in case I'm not here. Only if I'm not here. And then also begin to start thinking about which advisory boards, since we're beginning to start appointing, that you would like to be a liaison to also. So take a look at all our programs for the advisory boards and see which one you would like to be a liaison. Let me know, and then I will go ahead and appoint you to that. I've got to get that thing set up probably the next month or two. Also, the various committees that we have, audit, finance, bill implementation, which actually won't come into effect till next year once we get the bills. And what was the other one that we were doing?
Innovation was the new committee that was
Right, a
recommended.
new one.
by
I tell you, we had a great recommendation during the board orientation, our commissioner orientation, by our very own Commissioner Figueroa, who mentioned about having a subcommittee of innovation and working with our Office of Innovation, which I thought was an excellent idea. So we'll be looking at appointing that also, so if you're interested in that, again, let me know so we can make sure to get you on that. But we do have audit finance we need to have on there. We have innovation, bill and implementation. Didn't we have one for penalty matrix? But we don't need that anymore. We had three, I remember that. I'm trying to figure out what the third one was.
Audit strategic plan and.
Strat plan, that's right, LAR, which fell under
Strategic plan, because they're.
together, okay.
Mr. Chairman, we have Kay Mahan, she's queued up to send out a questionnaire to the commissioners.
Perfect.
So it'll list all the programs and allow them to rank their top 6
Right.
advisory boards so that we can.
And that way we can get that
gather
done. And there will be some on there, but if you get appointed to another board that you didn't have on your list, it's because we were short individuals and you drew the short straw. So, or the long straw, depending on how you look at it.
Mr. Chairman, if I could bring one thing to your attention in regard to the advisory boards. We've discovered that, so the advisory board for dyslexia therapists and practitioners is an advisory board that is created by rule, just like the combative sports. We've discovered that The practitioners, there's about 56 of those folks, and they're transient because they ultimately become dyslexia therapists. So that pool and that universe is extremely small, and it's very temporary. We may come back after we do some analysis to the commission and say, let's just make that 3 dyslexia therapist members and not always try to find that person who's in that little window for 2 years and 3 years. But we want to do a little bit more analysis on that, but we think that's going to be the right way to go.
Right, yeah, I agree. All right, let's go on to item Q, advisory board reports. We have anything to be brought forward? I got a no on that one there. Okay, we'll move on. Public comments. At this point in time, if there's anyone still here that would like to make a comment, I'll go ahead and bring this back up and you allow 3 minutes to speak. I see our regular is not with us today, so I'm sure he's somewhere safe.
Nice.
That is him being nice. You gotta hear him on a bad day.
Okay, item S, which is our discussion of future meetings. Let me go back right quickly. I can tell you that our meetings are currently set for, and make sure you have this in your calendar. Next meeting will be July the 27th. We have a meeting on August the 24th. I think we had tentatively set a meeting up for, what was it, October, was it the 12th? Is that correct, or the 19th? We'd set up a tentative date.
The 5th.
The
The
first
5th.
Wednesday.
The 1st, okay. So October the 5th, and I had you take a look at your calendars. We didn't get anything back, so let's go ahead and solidify that for October the 5th. And I think the next one we'd probably need to have right before Thanksgiving, which would be about November the 16th, which is about 7
August
weeks out.
29th is a Monday?
I'm sorry,
No, it was August.
24th.
August 24th.
Okay, August 24th.
Yes.
Okay.
So we have July 27th, August 24th, October 5th, and I would say right now, tentatively, we're probably looking at about November the 16th. That's 6 weeks out. Well, that'll be tentative.
I will not be here on the 27th.
July?
I'll be here for the August, but I won't be here for July.
Mr. Chairman, we are working out some dates in terms of the first
LAR.
rewrite of the, I was going on the LR too, but first rewrite of the driver education safety rules. So we will give you a date. It'll be an October time period, I think, that we're looking at.
I think we're looking at, this is Stella Lindquist. I think we're looking at the November meeting to adopt, though.
Okay.
And then hopefully to be effective January 1st.
So at this point in time, you're thinking November 16th may be okay?
It should be.
Okay.
Yeah.
Well, let's work on that. We'll make that as a tentative one at this point in time.
And then the other thing to keep in mind is we have not received the instructions yet for the legislative appropriations request. So no agency has received it.
And that'll adjust it.
Yeah, we may have to have a meeting sooner in July or later in August. We don't know yet when our documents due. The staff is working on the legislative appropriations request as if we've already received the instructions.
Now, let me ask you this. We've done it before. I don't think it's anything that we really push for, but if we need to have just the LAR information, we can probably set a meeting up and Skype that.
We did the last time, that's
We
correct.
did that, so leave that open because
Yes, sir.
we may be able to just simply Skype everybody in as opposed to having everybody come in just for that one agenda item.
Okay. We'll look
Okay.
back to last, 2 years ago and make sure
Yeah,
that we're.
we did that, that's what I say, I think we did that about 2 years ago.
Correct.
So you won't need to Skype, you can come in. We'd hate to Skype. So, if there's no other agenda items, I believe, yes.
We have a VIP over here we need to acknowledge, a 5th grader.
That's true.
Absolutely.
A prospective executive director one day of the agency.
Well, I hope she shoots higher than that.
You want to introduce yourself? Rick, is there anybody you want to introduce?
Yeah, of course, you know Joey, he's an intern, and then to his left is my oldest son, Nathan Figueroa.
Nice, very good.
Well, it's great to have him here. Yeah, I think you probably want to aspire higher than an ED. Let's just go for governor.
I think it's EDDD, TBD.
So, welcome everybody, and now goodbye everybody. That should adjourn our meeting, so this meeting is adjourned.